Please give you a number.
Make a mention, my lord.
Sir, the adjournment I got लिखिए से March we commencing 16 March. ठीक ଅଛି Mr. Bhuya, we commencing 16 March.
Yes.
Then Mr. Sethi, item 34 केबे रखछन 23rd March. तो बोले जोड़ा लेटर मैटर था ठीक है. Then 30 who's fine.
9th.
We commencing 9th March.
9th March.
9th March. Okay. 24
16 March.
24 टा 2016 बसिया सेटा को 9th March रखिए आरोड़ा को ता परकु दे
24 9th.
अपन निजे लिखि रखुछन ना हां पोस्टिट तापर हां ठीक है तो तो रिलीज है डिस्पोज्ड ऑफ ऑर्डर डका हो यस और मेमो देले कॉल द लिस्ट
Item 1.
Your Lordship. Your Lordship, on the last.
Mr. Lenka wants to say something. Yes, Mr. Lenka.
No, last occasion, they made a submission before Lordship that the petitioner both has been died. And your Lordship has seen the noting was application for substitution of the deceased was to is not fine.
See, the other difficulty is that after 25 years, quarter of a century, they do not know who are the legal heirs. Ms. Charvi, my suggestion is that let it be closed with liberty to revive by the legal heirs.
Your Lordship, we had contacted the legal heirs, but due to some personal difficulties, they have not been able to get back to us. If your Lordship may grant us some more time.
They may not actually. They may not because after 25 years, who will pursue litigation? I mean, the pendency actually is many cases that are not required to be kept like that.
Lordship may grant one.
Some service benefits, Mr. Lenka, so legal heirs can also be substituted.
Yes.
So let us see. How much time?
2 weeks, Your Lordship.
Mr. Lenka, order dated 15 and 26.
Yes, Your Lordship.
Apana, both are connected.
Both are correct.
WPC 16984 of 2006.
Same petitioner, two
Again. Sub item tra upon likhchunti. Ms. Charvi on behalf of Shakti Sekhar for the petitioner. On 15/1/2026, the following order was passed. Para 1, Para 2. Lord AG, referring to the said order, submits that substitution has not yet been filed. Sub-para later. Ms. Charvi, Lord Counsel, submits on behalf of the petitioner that they have tried to contact the legal heirs of the petitioner, awaiting their response. They require for the time. 2 weeks के आज कितने थे? 10. So we are listing it on 24th February. List on 24/2/2026 under the same heading. The same priority 20 years.
Yes.
Much obliged.
But priority 20 years, they will think that the registry doesn't know mathematics. 2006 is 20, 2001 is 25 years. Now another heading has to be there, priority 25 years. Yes.
Much obliged.
Try to get it.
Yes, Your Lordship.
And you can explain them that the court will grant liberty to revive.
Yes, Your Lordship.
Item 2.
Mr. Manoranjan Mishra for the petitioner.
During discussion, the petitioner is filed challenging the order dated 16/1/15 by the annexer 1.
After 10 years, anything survived, Mr. Mishra?
My lord,
Have you obtained? You are challenging a judgment of 2022.
15, my lord, that the interim maintenance which has been granted in favor of the opposite party by the annexer 1.
Interim maintenance under 125 CR.
125. Much obliged to that extent.
So then what happened? He's not paying.
No. I am challenging the maintenance which has been granted, which is contrary to the judgment which has been passed by the family court for restitution of conjugal right that has been allowed. So keeping with the decision of our Hon'Ble High Court that
There is no such provision in 125. It's a wrong submission.
no, so far as restitution of conjugal right is allowed.
Restitution. So kindly read.
Yes, sir, I am giving my lord. So far as
Yes, sir,
restitution of
Let me not speak on this. Let us go through the statute.
yes, my lord.
Kindly take 125.
125(4), my lord. When the restitution of conjugal rights is allowed,
Kindly read, sir. I cannot.
Yes,
speak
yes,
from I do not have asked for
page 25. Page 25.
125.
Yes, my lord.
Yes. Kindly read.
Just a minute. So, CR 125(4) CRB provides that. My lord, got it? That a
I'm
wife.
holding the book. I have to get
Eh,
it.
ho, acha,
You are
sorry,
not holding anything, so I am in doubt, sir. How
এটা
can you-
judgment পড়েছে সেই মুখে
Judgment পড়েন তুমি।
আজ্ঞা
He is as bad as me.
না
also.
ସେଥିରେ ସେଇ କୋଟ କରାଯାଇଛି 125(4) ଟା କୋଟ କରାହେଇଛି ବୋଲି ସେଥିପାଇଁ ପଡୁଛି ସେଥିରେ 125 is there. No wife, madam, got it?
125(4).
Married.
Yes.
No wife shall be entitled to receive an allowance for maintenance or interim maintenance and expenses of proceeding, as the case may be, from the husband under this section if she is living adultery or if without any sufficient reason she refuses to live with her husband. Or this is my point.
So kindly take that plea in 125 written statement. Why you have stated?
Just I'm going. So far,
Then how it can be justified?
I'm coming.
You not spend time on pleadings.
No. I am saying the order has been passed by the family court directing for restitution, my lord.
Correct.
That has not been challenged.
Sir, 125, where you have taken that plea, I am asking you. Show the pleadings.
No,
I am with you. You are not listening, perhaps. I am with you. Where
Yes,
you have
my
taken that plea and how?
yes, that is there, my lord.
So what is your written statement?
Yes, my lord. That has been taken into consideration, my lord. And the order has already been passed in 2022, my lord.
In 125, where you have taken that plea? And
Yes,
what
my
is the
lord.
response?
Just, my lord. With receives permission. My lord, at page 22. Got it, my lord?
I'll get it. Definitely, I'll get it. 22 of what?
Para 9.
Yes.
The opposite party has further stated in his evidence
Oh.
that he had filed CP number 120 of 2023
Oh.
under section 9 of Hindu Marriage Act against the petitioner before this court, which was finally disposed of on 16/1/2015, and the petitioner was directed to join with him for restitution of conjugal rights within 2 months. He had further stated in his evidence that after final order passed on 16/1/2015 in CP number 120 of 2013, he had requested the petitioner several times to come and reside with him as husband and wife, disclosing the said order 16/1/2015 of this court. But she refused to come and stay with him as husband and wife, knowingly well about the order dated 16/1/2015. He has approved the photocopy of the judgment dated 16/1/2015 passed by this court in CP number 120 of 2013 under section 9 of Hindu Marriage Act.
I'll read further. That is not the. Read further.
Yes, my lord. The petitioner had admitted in para 16 of her cross-examination that her husband had filed CP bearing number so and so for restriction of conjugal rights, in which she had contested, my lord. May I kindly see the, or if I'll
Don't add anything.
no, I'll bring.
Sir, I completed with you.
No, no.
My difficulty is that
Just for a moment, to that
Leave a
extent,
comment on that.
she had contested what she is, that is reflected, my lord. To that extent, the judgment will clarify everything. The Annex 3. And this court had ordered that 16/1/2015 directed her to go to the house of her husband and to live with him. But she had not gone to him as she was apprehending risk to her life. She has further stated in her
I will
cross-examination.
stop there for a moment.
My lord.
Cross-examined her.
My lord,
Who cross-examined her? You.
no,
So kindly read then further.
yes,
So
so far the threatening is concerned, my lord.
No, I cannot. I am not threatening. You are not reading, sir. Kindly read, then you will understand the logic.
She has further stated in her cross-examination that she is not interested to go to the house of her husband and to live with him as she is apprehending danger to her life. She has further stated in her cross-examination that she is not at all interested to go to the house of opposite party and to lead marital life with any condition. The learned counsel for the opposite party argued that as the petitioner has violated the order of this court under Section 9 of Hindu Marriage Act, she is not entitled to get any maintenance. On the other hand, the learned counsel for the petitioner argued that the life of the petitioner is full of danger in the hands of the opposite party as the petitioner has lodged the affair against the opposite party and the said criminal case is still pending in the court of law in SDGM Kendrapada. The learned counsel for the opposite party has relied upon the judgment of the Honorable Court in Balaram Das case Swanso, in which the Honorable Court has held that therefore, in view of the fact that the decree of restitution of conjugal rights has not been complied with by the wife prima facie, it must be taken that the wife has refused to live with her husband without sufficient reason and is disentitled to claim maintenance. In this case, earlier the husband had filed a proceeding under Section 9 of Hindu Marriage Act, which was decreed in his favor, but without comply the said decree, the wife had filed a proceeding under Section 125 of CRPC claiming maintenance against her husband. But in the present case, the proceeding under Section 9 of Hindu Marriage Act was disposed of on 16/1/2015, and 1 year prior to that, the petitioner had already filed this criminal proceeding for maintenance on 2/2014. So it means before disposal of CP 120 of 2013, the present criminal proceeding was pending. As the CP numbers 120 of 2013 was disposed of earlier to the present proceeding, the opposite party cannot take the advantage that in the midst of this proceeding, the right of the petitioner was curtailed due to the order passed in CP number 120 of 2013, directing her to comply with the order. Moreover, in Balanda's case, there was no pendency of any criminal case between both the parties, and the wife has also not taken any plea that her life was in danger in the hands of her husband. So, in the above discussion, this case is not applicable to the present proceeding. On the other hand, the learned counsel for the petitioner has relied upon the judgment of the Honorable Court passed in so in 2020-17 OCR, in which Honorable Court was held that she is tortured under her in-laws house physically and mentally, cannot be decline maintenance if he leaves her husband's company for that reason and lives separately. The learned counsel for the petitioner has also relied upon the judgment of the Honorable Court of 2018-69 OCR to 914, in which Honorable Court has held that Section 125(4) CRPC provides that a wife who is entitled to receive a maintenance, receive an amount of allowance for maintenance or interim maintenance or
That you have read.
well, that is there.
Yes, and read sufficiency.
That the opposite party also stated in his evidence
There is
that
sufficiency of reason.
well,
You are missing the paragraph.
that is sufficient.
Sufficiency of reason.
Sufficient.
That is the
Sufficient reason as contemplated under section 4 of subsection 4 of section 125 CRPC is a question of fact. Every reason or pretext put forth on behalf of the wife cannot be accepted for fulfilling such requirement. The cause shown must be a reasonable one in relation to her health, safety, unhealthy atmosphere prevailing in the in-laws house to lead a decent life. If the wife is satisfied subjected to cruelty and harassment in the hands of her husband and in-laws family members, and there is unnecessary character assassination of her for which she lives or matrimonial house and lives separately. It cannot be said to be a willful desertion on the part of the wife, and on that court her claim for maintenance cannot be rejected, even though in the present case the opposite party husband has not found guilty for the offences under which he has been charged on the first information report lodged by the petitioner number 1 wife, but that cannot be a factor also to refuse maintenance to her. The opposite party has also stated in his evidence that the petitioner has filed GR case number so and so against him under section 498A 506 IPC read with section 4 DP Act, which is pending in the court of the law in SDGM Kendrapada. Hence, as the criminal case is pending between both the parties, there is sufficient ground that the petitioner is apprehending danger to her life in the hands of opposite party, and for that she was not interested to go to the house of her or the opposite party and to live with him.
So thanks for your time. So you have already covered very fairly. Section 9 contention has been noted. The reliance of the opposite party on one decision of the High Court has also been considered. Then 3 decisions of the High Court, or rather 2 decisions of the High Court, which are equally binding on the same point, has been considered. So obviously that decision has a problem which you are relying, that is against you, because that says after restitution of conjugal rights order is passed, then she files 125. Here the case starts in 2013. GR case number 2013. Then she files 125. Then you file section 9. So that is what the decision has. That is how.
That is one accept. I accept. No. I'm not.
If you don't listen, then it will not register. If you say your point is well taken by the court, Section 9 order, like you kindly again read that decision of Balaram Das. You can read that.
No.
Kindly read and just now you read it.
Other 2 things I put, except that. So far the one thing, with her permission. No.
That's not jump around the case.
No, with her permission.
You are saying 125(4) be desentenced.
That is respect.
Your point is well taken by the court, discussed and rejected. Correct. Balaram Das, actually Balaram Das is partly against you.
Yes, madam.
Balaram Das said since the wife filed the 125 after coming off the decree in section 9 application, so that is not a plea. So whether Balaram Das had also other part, whether in 125, whether the husband can take the advantage of the situation where the wife is unwilling to come. That has been discussed in Churia, and the other one is Maharana. 2 cases. So that point is well taken. So 125(4), your submission is complete. Then what is the other point?
So far as the restitution of her conjugal right, she could have taken all these things, or that she could have challenged before the appellate forum, saying all those things, who divorce you?
Don't ask me questions.
No, my respect.
Your submissions are incorrect.
That could have been.
So your submissions are completely incorrect. Because you are confused actually. That is a,
No,
you should not have cross-examined her.
Maybe, no,
So you see, you are not the collecting counsel.
possibly say what I have to say.
So,
Because
you are asking questions to the court.
no, question.
Please don't ask to yourself because you are not the wife. If you say, I'll record that, I have to reject
No,
it.
no,
Your contention
that is
is-
up to your my contention is that
You are not listening. That's the question. I am saying you something, you are just trying to override me.
no, I can't.
My voice and my ability to speak is more than you. I can raise my voice also. Please listen. If you say that she has not taken a defense in section 9, that itself kills your case because it is 125. Your defense in section 125 is there, section 9 order is there, she has not complied. And that has been well taken. Balaram Das, for relying on Balaram Das has not helped you because Balaram Das has a timeline.
And Rajneesh Neha case is there, no affidavit.
Rajneesh versus Neha is much after this. Can you
No,
look?
maybe there is a decision.
Find out the paragraph where it says for 125 for awarding 2,000, 5,000, affidavit has to be passed.
If that is so, what I am saying.
No. That is it. I cannot start adding lines because Mr. Mishra says that Mr.
No, I bring to the knowledge of your
You cannot bring the wrong thing to my knowledge and I will accept it. Rajneesh versus Neha, treating 125, you see, if you read Rajneesh versus Neha, there is nothing that when 125 is considered alone, Rajneesh versus Neha considers 24, 25, 24, 125 and DV, all four. Because this 125 is a magisterial, you can look at 125. The family doesn't have authority.
No, so far the affidavit is concerned. So far the how it is disclosed. How it is disclosed that those are income.
Find that wherever the earlier cases where the affidavit was not filed and it has been decided, prior to Rajneesh versus Neha, those are set aside. Because that is the objective of Rajneesh versus Neha. And that is how in our High Court, for 5,000, 2,000, 3,000, High Court has consistently, no court has followed. Because Rajneesh versus Neha mandates it because you must understand. People are claiming in lakhs. The wife claims in lakhs.
That is about it.
Suppose somebody is told that you for education 15,000, then they say that my child will study in international school.
That after taking into consideration the affidavit which has been filed by both the parties, that does not mean that we are filing such an affidavit that can take into consideration.
That it has to be
that I have
versus Neha is against you.
It is my duty. I have to bring to the law which I am filing.
Make a wrong statement of that Rajneesh versus Neha bars 125 consideration and I'll accept it. I have to reject it. That's not difficult.
But even to that extent, the restriction of conjugal right, that does not mean she has not get an opportunity to challenge the same.
Sir, you are arguing against you. Either you stand by Balaram Das or you fall by it. You are relying on Balaram Das, you have fallen because Balaram Das has a timeline. And now the problem is that if Balaram Das is to be followed, then what about Surya and Maharana? The High Court has itself said. And what about that 125 is in the nature of a money decree, and when you do not comply, you cannot challenge it. So obviously that is the, Rajneesh versus Neha says that unless wherever the decision has been made and appeal is pending, it has to be allowed because no affidavit has been filed. And affidavit, you see, the contest here in Odisha is 2,000, 3,000, 1,000. 5,500 they are not paying.
No,
please appreciate that.
For clarification of the person concerned regarding their
I cannot apply. I cannot because there is a bar on me that it is a prospective operation of law. I cannot say it is retrospective. Whatever the decided, apply Rajneesh versus Neha and allow.
No, on the date of passing of the judgment, I am saying so.
Did you cite Rajneesh versus Neha? You please know that is against you. That's the problem is that.
By that time.
Balaram Das, you have fallen. Rajneesh versus Neha will fail you. I'm dictating the order. That takes some time. Yes. Mr. Bonojan, Mr. Opposite party blank. You take your seat.
Much obliged.
Slowly. The petitioner husband is before this court, challenging the judgment dated 21/9/2022, passed by the learned Judge Family Court Kendrapada in criminal proceeding number 1 of 2014. Stop. By the said judgment, the application filed by the opposite party wife in the marriage under section 125 of CRPC, claiming monthly maintenance, was allowed. Directing payment of rupees 3,000 were as monthly maintenance from 2/1/2014, that is date of application. Though the application has been filed in the year 2022, 23. The revision petition has been filed in the year 2023. Judgment the more judgment. Notices have not been issued. So Mr. Agur के लिस्ट न कला ना नहीं कला
Again,
Agur notice ही नहीं कला
no notice, the first time.
first, and the matter is taken listed for the first time. Ichiro cancel. Urgent record. पूरी The learned counsel for the petitioners is heard at length. The learned counsel refers to challenge in challenge to the judgment rendered by the learned judge family court. The learned counsel refers to section 125(4) of the CRPC into bracket since repealed and substituted by perimeter provision in BNSS 2023. So, section 125(4) is reproduced here. It is submitted that the petition, it is submitted that CP C.P.120 of 2013 was filed by the petitioner husband under section 9 of the Hindu Marriage Act before the learned judge family court Kendrapada, which was allowed by judgment dated 16/1/2015 on contest, directing the opposite party wife for restitution of conjugal rights within 2 months. It is submitted that despite the direction, the wife never joined the company of the husband. Therefore, 125(4) would operate, disentitling the wife for to receive any maintenance. Perusal of the judgment, which was extensively placed by the Learned Counsel for the petitioner, Mr. Misra. Mr. Misra, Learned Counsel, that at paragraph 4, the issues have been framed, which are thus, paragraph 4 of page 15 there. The evidence on record has been recorded at paragraph 5, and the same is reproduced. The marriage between the parties was solemnized on 7/7/2011. The contentions as raised before in the revision application was also raised before the learned judge family court. Which has been dealt at paragraph 9 of the judgment. The said paragraph is reproduced as it contains. As it contains all the references of the case law relied on by the parties. Current counsel Mr. Misra for the petitioner relies on rather reiterates that the decision rendered in Balaram Das versus Srimati Gitanjali Das and others reported kariben others pore kudita bitu deki colon deki 2000 into bracket Roman 2 where O capital L capital R capital 223 would come to the aid of the petitioner husband who was opposite party before the trial court for declining to give any maintenance. That quotation for lecture. Yeah, submission. Pura quotation for. Perusal of the judgment indicates that the learned trial court has discussed in detail the facts of Balaram Das. That the facts as depicted in the said case are different. Inasmuch as in Balaram Das, after pronouncement of the judgment and decree directing restitution of conjugal rights in a petition filed by the husband under Section 9 of the Hindu Marriage Act, the judgment and decree was perhaps not challenged. Balaram Das challenge is
No, sir, even if he has not participated.
Balaram Das, Balaram.
Yes, sir. Yes, I have not.
Balaram Das appointed counsel.
No, I have not gone.
What is fact judge charge?
Yeah.
Anyway, let us say that in your favor, Balaram Das challenge karna thila.
Yeah.
Perhaps not challenged. Can you take question? And a petition under Section 125 of CRPC was filed seeking maintenance. Therefore, it was observed by this court. For the citation, the division bench single bench देखिए, फिर ऐसे तो लिखी ना. Citation टा अच्छी, reference टा गाड़ी, boy टा गाड़ी लिखना होगा आपको, है ना? That quote कर देगा. therefore in view of the fact এটা পেজ 12 রে কোটেশন আছে কিন্তু আপন ডিসিশনটা কাটিକି দেখি নেকি কোট কোট ভুলভাল ছিল হ্যাঁ এটা কোট କରିଦେବେ in view of the fact ମୁଁ just ପଢି ଦଉଛି therefore in view of the fact that the decree of restitution of conjugal rights has not been complied with by the wife prima facie it must be taken that the wife has refused to live with her husband without sufficient reason and it is entitled to claim maintenance this is your summation so therefore to neki therefore in view to neki to claim maintenance ता ଅଛି ତାଥିରେ ଆପଣ ଚେକ୍ କରିବାକୁ ପଡିବ division by single bench ଦେଖିବେ the learned trial court has further examined to apply the principles of Balaram Das and has given a finding which is also not disputed that GR number GR case number G capital R capital case small in capital 4.1168 of 2013 was filed by the opposite party wife under section 498 into bracket capital A oblique 506 IPC read with section 4 D.P. Act which was pending before the learned STJ Kendrapada. Thereafter, the criminal proceeding number 1 of 2014 was filed which has ended up in the judgment dated 21.09.2022. During pendency of the GR case as well as the criminal proceeding, the husband, the petitioner husband in the marriage had filed CP जोटा लिखिले ऊपर under section 9 ସେଇଟା correct 120 under section 9 of the for restitution of conjugal rights. Therefore, the learned Judge Hon'Ble Court has held that the facts of the present case would not attract the principle laid down in Balaram Das. Inasmuch as prior to the judgment dated 16/1/2015 in CP number 120 of 2013, the GR case was pending since 2013 and the petition under section 125 of CRPC was also pending. Further, the learned Judge Hon'Ble Court has relied on Sanghamitra Maharana versus Balaram Maharana colon into bracket 2020 bracket closed 77 OCR 109. The page 24 रे अछि and has quoted the relevant paragraph. Then I quote कर दें. Versus the learned trial the learned Judge Hon'Ble Court has then gone on to rely on Puspanjali Churia and another versus Pranab Kumar Churia colon into bracket 2018 69 OCR 914 and the relied upon paragraphs are reproduced here. Page 25. This one would have been yes. The further contention is apart from 125 for Mr. Mishra is Rajneesh versus Neha.
No, not that. So far as the section 9 is not under challenge. Even if that is not,
Yes,
that is
right.
not
Yes, yes.
disclosed. There are such
It is submitted by the learned counsel for the petitioner for the submitted. Take it. I'm just trying to recollect that the judgment in the CP judgment dated 2015 jota 2015 has not been challenged in any proceeding. To so that
even if
so that it is has not been challenged and therefore it is binding on the opposite party wife. Yes.
even if not appear, even if the counter which has been filed later on, because the cost which has not paid by the opposite party, that was not accepted.
Counter कहले
So far as section 9, though appeared and filed counter, that counter is not accepted.
आपनकर problem है जे आपनकर जोड़ा strongest point has become your weakest point. Balaram Das has itself made a distinction.
Nine যদি সে ডিসক্লোজ করে দিয়েছান্তা সবু যাক তাহলে এভরিথিং চ্যালেঞ্জ সেইটা
Balaram Das cannot be Balaram Das cannot be better than Balaram Maharana because it is Das.
সেইটা মু
And also Balaram cannot be better than Churiya. The problem হচ্ছে Balaram Das রে এই জিনিসটা আপনাকে হিট কলা যে during pendency of the 498A and 125 petition you have filed section 9. বুঝপারছন্তি কি? So now the 498A is a matter of trial.
correct.
And here 125, though the family court is taking up, they cannot comment on the pending 498A proceeding. So Balaram Das, in fact, actually, Hodayuddha has backfired on him.
That
So Balaram, both are Maharana and Das, and then comes to Churiya. And Churiya has dealt elaborately. What Churiya has done, because you see, this is a common principle. As a student of law, ଆପଣଙ୍କର dejection ରେ କ'ଣ common defense? Because the word itself is very clear, the statute is very clear, without any reasonable clause, not clause, sorry, without any reasonable clause. So Balaram Das has also taken care of that. Balaram Das, you should not have cited, nor you should have, not you, the person should not have cross-examined. At times, the lacuna in the case is provided by the cross-examination. So a lawyer like you, if he's appearing for the petitioner, definitely, it is actually, it's a very well argued matter. We do not realize that in trial court how good they are. সেটা তো সে ফাইল করথিলে জজমেন্টটা ডিক্রিটা আছে তাଙ୍କୁ কোন পচারিବାର ଥିଲା ইটস এ একাডেমিক ডিসকশন মিস্টার চক্রবর্তী আর সো মেনি ট্রায়াল কোর্ট লয়ার্স আর देयर ତାଙ୍କୁ ପଚାରିଲେ ଆପଣ କାଇଁ ଜାଣନ୍ତି ମୋର ଆଜ୍ଞା ଜୀବନ ପ୍ରତି ଭୟ ଅଛି ମୁଁ 498 କେସ୍ 2013 ମସିହାରେ କରିଥିଲି 11 ମସିହାରେ ମତେ ବାଡେଇଥିଲେ ମୋର ଭାଇ ଆଉ ଯାଇଥିଲେ ବର୍ତ୍ତମାନ ନାଉ ଦ ଏଣ୍ଟାୟାର କେସ୍ ଗୋଜ୍ ଆପଣଙ୍କର ଯଦି ଡିଫେନ୍ସ ଅଛି ଡେଜେସନ ର ୟୁ ହାଭ୍ ଟୁ ବି ଭେରି କେୟାରଫୁଲ ଇନ୍ ଡିଫେଣ୍ଡିଂ ୟୋର କେସ୍. Mr. Hon'Ble Mishra was for the petitioner there. Simple answer देला जे मोर आगे
they have done.
आपण ମୁଁ କହୁଛି how well they conduct the case. No court can override this kind of এই ପ୍ରକାର cross examination ହେଲେ କି ଯଦି ଆପଣଙ୍କର ସାକ୍ଷୀ ହେଲା pleading ରହିଲା and then the lawyer is ready with Churiya and Maharana. But then he fires the salvo. No. Now the court I cannot overcome. Even if you argued so well, you have a valid point. In fact, I was thinking the section 9 direction violate locally came to about. But when the court has considered, court has gone by the dates. When the says after section 9, 125 file karagala, golani. Section 9 comply him.
Correct.
Even one division bench I was sitting in section 9 appeal, we have imposed security.
Another thing
which is very unusual.
Another thing is
before section 9, the appellate court here.
Another thing is there to that extent, even in this section 9, he has not challenged, he is yet to say anything else later on. That's why I am saying.
Who is the step?
That opposite party, because he has not challenged. She has not challenged anything, not whispered a single word. So under section 9, who debar him?
Mr. Mishra, how many section 9s are implemented? That is how I gave you this example. Even the Section 9,
That is
constitutional validity is challenged. That has been upheld in the Andhra Pradesh case. That against a will, how the court will compel a person. Then just imagine last week, the Supreme Court has said that court cannot say that determine the life of a child. If the mother decides, mother will terminate. The judgment of the Bombay High Court is that let the baby be born. It is already 30 months, 30 weeks old, and it will be given in adoption. But the Supreme Court says that it is individual's choice. And here, by citing the lawyer knows how to handle Balaram Das. He has fired Balaram Marana and Churia Marana. That two decisions, and most likely, that would be a division bench decision also, even binding on me. Coordinate bench equally binding. But division bench, I cannot differ with Marana and Churia. Yes, one minute. CP 120/2013 16/1/2015 wife. In considered opinion of this court, the learned judge family court has taken care of has delved into the said aspects. Inasmuch as it has considered the dates of filing of all the 498A case, the criminal case under trial, date of filing of the petition under section 125 of CRPC, date of filing of the application under section 9 of CPC. Stop. The learned trial court has also partly relied on Balaram Das Supra to hold that. In Balaram Das, after filing of the judgment and decree, the wife had filed 125, filed petition under section 125 CR. Further, the judgments in Sanghamitra Maharana Supra and Pushpanjali Churia Supra have dealt with extensively with 125(4). And as has been correct, and as has been held by the learned judge family court, the said decisions are also applied with equal rigor to the facts of the present case. Next submission. It is submitted by the learned counsel for the petitioner that in view of the law laid down in Rajnesh versus Neha, Rajnesh RAJNESH versus Neha, Bipin Bihari alias Kalia versus Itisri. The parties having not filed any affidavit regarding their respective income and liabilities, the learned court, the learned judge family court would not have delved into the grant of 125 CRPC. So, in response to the state submission, on being asked whether if the contention is accepted, then Rajneesh versus Neha decided on dash should be prospective in application. The learned counsel for the petitioner fairly submits that the decision would be prospectively applicable, but the principle can be applied to the case at hand. But when further asked whether Rajneesh versus Neha lays down that in absence of the affidavit by the parties. A petition under section 125 CRPC cannot be decided to the extent when the court awards a meager amount of rupees 3,000 per month. It is also very fairly submitted by the Government Counsel for the petitioner that would not be that is not the mandate of the decision rendered in Rajneesh versus Neha. तापर लिखिए इन रजनीश वर्सेस स्नेहा कोर्ट करो para 14 पाइजिबे बिपिन बेरा para 14 case law then para 15 Samima Faruqi, scope of revision. So Mr. Samima Faruqi by
I have also mentioned, so
Samima Faruqi.
madam,
Samima Faruqi.
ମୁଁ ଆଉ କହିପାରୁନି ସେଟା।
ନାଇଁ ଆପଣ କୋଉଟା କହିଲେ ମୁଁ ବୁଝି ପାରିଲିନି।
So far as the Rajneesh case, I have categorically stated in para 8 that is what is the terms for the purpose of filing the affidavit. That so far as
No. The problem is that if I hold it is applicable, then I have to go there.
that is applicable because unless until affidavit.
No, sir. Rajneesh but date टा कहंतो अपन। ऊपर डिसीजन अछि। आपण एटा फाइनल है 24 रे। एटा फाइनल है 14 रे। Rajneesh decide ହେଇଛି ଆପଣଙ୍କର ନଭେମ୍ବର 4 2020 ରେ।
ଆଜ୍ଞା।
ଆପଣଙ୍କର this was filed in 2014.
But so far as the CRPC decided on 21/9/22.
Sorry?
21/9/22.
Correct.
Yes.
So you have not cited that. That is not your plea. ଆପଣ ସମୟ ଫରକି ପଡିବ
ସେଇଟା ତ ସେ କରିନା କଣ କହିପାରିବି
ସେଟା ମନା କରିଛନ୍ତି you have to I mean the language in fact very eloquently written by Honorable Justice Deepak Mishra. Samima Faruqi, I'm asking you that only. The role of a revisional court. So that is how I am also relying on Rajneesh versus Neha.
That should be.
Yes. Rajneesh versus Neha I have to rely on. Because Rajneesh versus Neha expresses concern regarding this, that non-compliance of orders passed in 125.
That's why they.
So kindly now, since you are not having Samima, I'm just reading Samima. Honorable Justice Deepak Mishra.
Okay.
As is manifest, the High Court has become oblivious of the fact that she has to stay on her own. Needless to say, the order of the learned family judge is not manifestly perverse. There is nothing perceptible which would show that order is a sanctuary of errors. In fact, when the order is based on proper appreciation of evidence on record, no revisional court should have interfered with the reason on the basis that it would have arrived at a different or another conclusion. When substantial justice has been done, there was no reason to interfere. There may be a shelter over her head in the parental home, but other real expenses cannot. Anyway, that's the reason. But the scope of revision is very aptly said by the Supreme Court. I'll be precisely doing that because there is a possibility by applying Rajneesh versus Neha retrospectively, a different conclusion would be arrived.
Naturally.
So that is how I'm relying on. And in the interim order, 125 was entertained, interim order is passed.
Oh, yeah.
That was Shiva Devi versus Anand Prakar. No, kindly listen. I'm saying it is academics, pure academics.
Correct.
So kindly listen to this, the language used. You have now heard Justice, I have read Honorable Justice Deepak. Now the other judgment.
Oh, yeah.
We are constant to observe that this order shows total non-application of mind on part of the High Court. This was a case where maintenance had been granted to a wife and a minor son. The High Court, without recording any reasons whatsoever, has stayed the grant of maintenance both to the wife and to the minor son. This should not be done. So the court would have very well said that you approach the High Court and we are fixing a date. But the interim order was set aside and the High Court directed that you consider. So you must understand which direction the wind is blowing.
No,
So that was
my intention is to that extent.
Sneha is not the way to be interpreted as you are saying.
No, so
To stifle the claims of a wife that you have not filed.
no, so for that,
affidavit.
no, what is the purpose of that extent? I have categorically mentioned in para 8, my lord, with the permission of place to that extent, that for that purpose, my lord.
Paragraph 8.
So for as financial capacity of the husband, my lord,
Appeal memory.
yes.
সেটা আপনাଙ୍କର কোଉଠି প্লিডিংস ରେ ଥିଲା সেটা ଦେଖିବେ
No,
ନା
no,
ମୋର ପ୍ରୋବ୍ଲେମ
এটা সে মানে ନାହିଁ
That is the
ସେଠି
problem. Samima Faruqi is a bar on me, stares at me. High Court has no vigilance, it says. What strong language the Supreme Court has used. That's the problem. ଆପଣଙ୍କର better argue ହେଇପାରିଥାନ୍ତା ସେ matter. Could be. Possibly, I don't know. Even ସେଥିରେ ଆହୁରି ହୁଏତ ମାନେ ସେଥିରେ ବି dismissal ହେଇଥାନ୍ତା ମୁଁ ସେ କଥା କହୁନି. I mean, sorry, the allow ହେଇଥାନ୍ତା. But ସେଥିରେ there is no point in re-arguing the matter in a revision. ସେଥିରେ ଆମେ କାଇଁ ପଶିବା ସେଥିରେ. We will be spending time on that. In view of the above, the petition being devoid of the revision application being devoid of any merit is dismissed. While parting with the case, this court puts on record its appreciation for the able assistance rendered by the learned counsel for the petitioner for disposal of a matter which relates to the cause of action of 2014. Yes. Yes, next. Mr. Mahanti, please. Yes.
That item 3.
नहीं एटा टू गला ना थ्री टा देबे आपण मते मेमोटा बढ़ेबे नो मिस्टर महांती टेक योर सीट देयर इज वन मोर मैटर मिस्टर मनोज कुमार पप्पी पर द पिटिशनर बस ऐसे कौन से डेट उडा जोड़ा पोस्टिंग करेगा था करंतु इस समय The petitioner husband in the marriage is before this court, challenging the judgment dated 17/3/2023 passed by the learned judge family court, Balangir, in CMC number 13 of 2022. Stop. CMC number 13 of 2022 was filed under Section 5 of the Limitation Act. Was filed under filed invoking Section 126 into bracket 2 of CRPC into bracket since substituted, since repealed and the perimeteria provisions substituted by since repealed since repealed and substituted by perimeteria provision contained in VNSS 2023, bracket closed. Sentence से complete तो है filed under Section 126(2) for setting aside ex parte order and restoration of the case, that is CMC number 3 of 2021. CMC number 3 of 2021 was filed under Section 125 CRPC by the opposite party wife in the marriage on the claiming monthly maintenance under section 125 of CRPC. So that it is say it will tell it so obviously. The matter was posted on 31/8/2021. After on 21/9/2022 2021 2021 the opposite party was set ex parte, opposite party husband was set ex parte, and on 06.11.2021 the judgment and decree was passed allowing the section 125 CRPC petition. After filing of the revision application before this court, the Purva line likhibe, the said application filed under 126(2) CRPC was rejected along with dismissal of the petition for condonation of delay under section 5 of the Limitation Act for setting aside the ex parte judgment. In sentence in the year 2023, nothing much has happened. Notices have not been issued. The matter has not been listed, though filed on 25/4/2023. The learned counsel for the petitioner files memo of date which states thus, quote कर दे रहे bracket में लिख देंगे sickness size bulbal in this size. Accordingly, the matter stands disposed of. Copy of this order shall be forwarded to the learned judge, Family Court Balangir, to be kept on the records of section CMC number 13 of 2022, disposed of on dash. Purva matter to you say, copy of this order shall be forwarded. Your disposal is to पठाई देउछन्ते.
Item 4.
Mr. Dwarika Prasad.
Yes, sir. The last judgment to your lordship, questioning that award passed by the Lok Adalat, whether it should be challenged before this honorable court or
No, what has happened yesterday? I hope you are not there. I think yesterday. So in fact, I could not get further clarification at this stage. That because the Supreme Court says that even appeal can be filed in certain cases if you go through those two decisions.
Jalor Singh and others.
Jalor Singh and then the latest one is Raja Krishna.
Yes. Judgment of this honorable court is 2026 1 OLR 189.
They are actually the problem is that Jalor Singh and have not been referred to. Only that last paragraph. But
No.
prior to para 37, 33 has not been referred in that case. In fact, I was discussing whether it has to be referred to the larger bench.
And
Because that case is again argued. What has happened? 2026. So then the court directs you file writ application. That writ application was listed yesterday. So to read that paragraph, that is not the only paragraph in this. Jalor Singh has been followed in Bhargavi construction. Bhargavi says that Jalor Singh has to be followed.
yes.
Bhargavi para 37. But in that particular case, Bhargavi has said that in this case, you have to go for file a writ application. But that is not the ratio of neither of Jalor Singh or Bhargavi. Now
Jalor
kindly take look at this Mukund Bhavan Trust.
That I have not brought today.
So I'm issuing notice now. Issue
Yes.
notice on the question of admission. Actually.
Yes, yes, that's because here.
So, but I mean, honestly request your assistance on this
Yes, yes, I'll definitely.
because it's a very serious thing, Mr. Mahanti. Lot of effort is made. Lot of effort is made for Lok Adalat.
Yes, definitely.
The commitment of lawyers shown by the lawyers especially is phenomenal. Because for us it is disposal, but for a lawyer, he makes a lot of efforts. But in 2 lines, I'll be, setting aside Lok Adalat agreement. Settlement, not agreement. When the other side has agreed, both the parties have agreed. So yesterday, one matter is MSCT case. The person says that I should have been a party. I have not been made a party. Where High Court has said that only you have to file because he filed CMP. They are CMP. I think CMP is filed for setting aside non-gender necessary party. CMP is allowed by the trial court, Lok Adalat court, trial court. Against CMP, the other side came here, filed CMA. The Lord Single Judge has said,
Trial court, it should be CM.
please don't mind my saying, but
Yes.
because since you understand, I am saying,
Yes, yes,
I
definitely.
can say X, Y, Z also, but I am saying trying to. So now this court has said in 227, writ court, CMA is not maintainable. But if you read Jalor Singh, also that builder, construction, Bhargavi construction, it is very clear. Appeal is maintainable. And in case of the other aspect is that in case of fraud, the law is well settled since long. House of Lords,
It can
fraud
be
rivals everything.
It can be
and I follows that
at any time and before any forum.
any time before any court. So that is what Bhargavi. So this if somebody is then and now the other aspect, anytime before any court, very correctly said. Which court is the best court to consider that? The trial court.
Even here also.
So now, Mr. Mahanti, suppose now I remand it, it goes to trial court. Trial court on its own has taken up the matter.
Yes,
Now, what you call CMP.
CMA.
Here,
Miscellaneous application.
here it is. It is CMP. Okay. Trial court allows the CMA takes up the matter. You file a CMP here. No, sorry, you file a writ here. I ask the trial court to trial it because I am not the trial court. Then the result is also same. So there I do not agree with that view. In fact, the trial court did the right thing. That is the mandate of that it allowed the CMP.
Again, all the Supreme Court judgments have to be placed and again.
Yes. So
Because
trial court did the right thing, I think. Yesterday, though I have issued notice, but my understanding is that after issuing notice, appearance of parties, according to you, what order I will pass?
Have to be referred to the trial.
Yes.
Even in this
So
particular
after
case,
much effort, even I do not know whether notice will be sufficient.
that is
Like today's matter, after 20 years, substitution is not done. 25 years actually.
in this
So-
particular case, in fact, again it has to be adjudicated by the trial court because a particular property was acquired by the government for a particular
I
purpose.
do not have in Odisha, the appellate court doesn't have the original jurisdiction. Entire jurisdiction, it may be civil justice senior division or the ADJ or the DJ. So it has to be it has to go to trial. And if the same court is trying that matter, can the same court doesn't have jurisdiction to say
What is the
that
necessity of saying
trial
that?
rivals everything at any time before any court? The CMP is a good solution. By simply saying that we elevated that since it is a Lok Adalat, it is untouchable. Nobody can touch it.
Is the
CMP is
language, why that language was used in the statute, Legal Services Authorities Act, that is also, that language itself is making the problem.
Correct. Correct.
Otherwise, on order 23, it is always the trial court.
Always the trial court.
Otherwise, it cannot be.
Yes.
That principle should be applied here also.
Sir, kindly, the order 23 is very clear in
Yes.
this Bhargavi. It says order 23 is maintainable. In certain cases where, because you see, then the purpose is that even after a compromise, still we rake up a issue. To prevent that, some language is used.
Any notice पे kindly be issued?
Yes, definitely. Since, in fact, after deliberating, thanks to the bar, they have assisted me and educated me. So I have started it. Yesterday I issued notice. Mukund Bhavan Trust is 2024 into bracket 15 SCC 675. MUKUND Bhavan BHAVAN Trust versus Srimant Chhatrapati Udayan Raje. Speaking. (2024) into bracket 15 SCC 675. This is on the same point.
Yes.
It has to consider this. Petitioner, little appearance section, opposite party blank. You take your seat, I'll take some 2-3 minutes to dictate.
Yes, sir.
The petitioner is before this court challenging the order, order oblique award dated 24.02.2013 passed by the Lok Adalat, Balasore in C.S. number 1069 of 2011. The petitioner has also sought for recall of the said award. The grounds of challenge is the petitioner has not been heard or not made a party.
No. Property acquired by the Land Acquisition Authority has been included illegally.
Okay. The grounds of challenge is that, as would be evident from the schedule of the properties to the suit, CS number 1069 of 2011, the property that has been acquired by the process of land acquisition has been included. Issue notice and admission, keeping all the questions of law open regarding admissibility of the petition. Stop. Notice be issued along with this order. Stop. Requisites for issuance of notice by speed post with registration, not oblique. Speed post with registration and proof of delivery be filed within 5 days or 7 days.
7 days.
Within 7 working days. List after SR, liberty to mention.
In the meantime, that
Here, is there any apportionment of any award? Monetary relief?
It is land.
Because then what is happening? Suppose yesterday that matter where
That was all. Here,
so here's
lands were
compensation, then my injunction will frustrate the local Adalat decree. So that is again frowned upon by higher courts. Even after local Adalat settlement, I unsettle it and the money is not released. So what I thought that I retained the share that is being challenged, the rest amount you can take. Retained in the sense, retained in fixed deposit by the requisitioning authority and with a high interest yielding account. So in that case, I have to pass that order in your case if any money parties comes.
No, here it is partition.
Only partition.
Only partition. It can be state operation of the award.
Yes. IA 4621 of 2025. ଆପଣ ଗୋଟେ ରିଟର୍ନେବଲ ଉପରେ ଯୋଉଟା ମିସୁ ନୋଟିସ୍ ହେଲାନି ରିଟର୍ନେବଲ ଡାକିଥିଲେ ଆପଣ ତ ଚେଞ୍ଜ କରିଦେଇଛନ୍ତି ଫିକ୍ସିଂ ରିଟର୍ନେବଲ ଡେଟ୍ ଟୁ ଆଜି ହେଉଛି କେତେ 10 ତାରିଖ ରିଟର୍ନେବଲ ଡେଟ୍ ଟୁ 10 ମାର୍ଚ୍ଚ 2026 list in the week commencing 23 ମାର୍ଚ୍ଚ 2026 liberty to mention ଉପରେ ଲେଖିଲେ ହେଲା ସେଟା ତଳେ ଲେଖିବେ କି ନହେଲେ ଯାହା କରିବେ ରିପିଟ୍ କରିବେ ତ ଚେଞ୍ଜ କରିବେ IA 4621 of 2025 had ordered counsel for the petitioner. He reiterates his submissions as noted above. Para. Issue notice as above. Accept one set of process fee as well as postal requisites along with the petition. List as directed above. Well, list after SR as directed above. Liberty to mention the upare bhi thibo. Yes. Yes, as an interim measure, it is directed the operation of the award dated dash past in dash by the so and so shall not be given effect to till the next date of hearing.
Item 5.
Yes, please.
My Lord, conducting counsel, SK Mishra is going to funeral ceremony of his father-in-law,
Sir, your name, sir?
C. Mohanty.
Marriage of father-in-law? What you said?
Yes, father-in-law.
Marriage?
Yes.
Funeral.
Sorry.
The copy, they have not solved, let them solve the copy.
ଆପଣଙ୍କ ନାଁ ସାର୍?
C. Mohanty.
ପାୱାର ତ ଅଛି ବୋଧେ ନା କଣ? ମିଷ୍ଟର ସି ମହାନ୍ତି ଫର ଦ ପିଟିସନର ମିଷ୍ଟର ଗୋଟେ କପି ଦିଅନ୍ତୁ ଡିଫେକ୍ଟ ନାହିଁ କିନ୍ତୁ ମିଷ୍ଟର ଲେଙ୍କା ଦେବେ ସେ ଯୋଉ ଅନଲାଇନ ଫାଇଲିଂ ରେ ଟିକେ ପ୍ରୋବ୍ଲେମ ହଉଥିବ ଆପଣଙ୍କୁ କୋଉଟା ଡାଉନଲୋଡ ହେଲା କୋଉଟା ହେଲାନି
ଅଫିସରେ ବି ନାହିଁ ଫାଇଲ
ଏଇଟା ଆପଣ ପେପରଲେସ୍ କରିନାହାନ୍ତି
ସେ ସିବିଆଇ କୁ କପି ଦେଇଛନ୍ତି ସେଇଥିପାଇଁ ଗୋଟେ ଡିଫେକ୍ଟ ଅଛି
ହଁ OP1 ପାଇଁ ଆପଣ ଦେଇନାହାନ୍ତି ବୋଲି ସେ କହୁଛନ୍ତି ବଟ୍ ଆପଣ ଷ୍ଟେଟ୍ ଅଫ୍ ଓଡିଶା କାହାକୁ କିଏ ରିପ୍ରେଜେଣ୍ଟ କରିବ ପାର୍ଟି ବି କରିନାହାନ୍ତି ଆଜ୍ଞା ବାଇ ମିଷ୍ଟର ଡିଏନ୍ ଲେଙ୍କା ପାର୍ଟି ତ କରିବେ ଷ୍ଟେଟ୍ ଅଫ୍ ଓଡିଶା କଣ କଲେ କାହା ପାଇଁ ରିସିଭ କରିବେ
State ପାଇଁ
ସି କଣ ଷ୍ଟେଟ୍ ନିଜେ ଷ୍ଟେଟ୍ ଆରେ ଷ୍ଟେଟ୍ କୋଉ ଡିପାର୍ଟମେଣ୍ଟ ହବ କି କଣ ହବ କିଏ କଣ ଆପଣ ମେ ବି ଇନଫରମାଲ କୁ ପାର୍ଟି କରିଥିବେ ଯଦି ଇନଫରମାଲ କୋଉ ଡିପାର୍ଟମେଣ୍ଟ ଥିବ କଣ
2, 3, 4 ଅଛନ୍ତି ଡାଇରେକ୍ଟର ସେଣ୍ଟ୍ରାଲ ବ୍ୟୁରୋ
ନା ଫାଷ୍ଟ ପେଜ ଦେଖୁନାହାନ୍ତି
ଇଏ ପେଜଟା ଚିହ୍ନ ଚେଷ୍ଟି ପେଜ
ନାଇଁ ୱାନ୍ ଟା ଦେଖୁନାହାନ୍ତି
one ଟା
ଷ୍ଟେଟ୍ ଅଫ୍ ଓଡିଶା
State of Odisha.
ସେ 2 କି କନଭର୍ଟ ହେଇଛି ସେ ପେଜ ପାଇଲେ ବୋଧେ ତାପରେ ଯାଇଛି
ନାଇଁ ମୁଁ କାହିଁ ପାଉନି
ପେଜ ଅଛି
ଷ୍ଟେଟ୍ ଅଫ୍ ଓଡିଶା ରିପ୍ରେଜେଣ୍ଟେଡ୍ ଥ୍ରୁ କିଏ
ସେମିତି ଲେଖିନାହାନ୍ତି
ତାହେଲେ ତ ହେଇପାରିବନି ନା
ଷ୍ଟେଟ୍ ଅଫ୍ ଓଡିଶା କିଏ ରିପେଣ୍ଡ ଲେଖିନାହାନ୍ତି କିନ୍ତୁ 2, 3
2, 3, 4 ତ ସେଟା ମିଷ୍ଟର ଲେଙ୍କା ବି କହିଲେ କି ଆପଣ ତାଙ୍କୁ ସର୍ଭ କରିଥିବେ 2, 3, 4 କୁ ଏଇକୁ କରିନାହାନ୍ତି କାହାକୁ ପାର୍ଟି State is an abstract thing, faceless, and I mean, there is no body or face of a state. You have to make somebody a party. Otherwise, he also cannot represent. In absence of which call lekuni se pata chhadi douchi. Copy ଦେଇଥାନ୍ତୁ ଯେ ବଟ୍ ଆପଣ ନୋଟିସ୍ ଇସ୍ୟୁ କରିପାରିବେନି
Present through
ଆପଣ ଯୋଉ ସର୍କୁଲେଟ କରିବେ ଆପଣଙ୍କର ଇଏ ସିଷ୍ଟମରେ
what I have seen there, my lord, his prayer is to transfer the OPID case to CBI court.
OPID केस जो डिपार्टमेंट लॉन्च करूची OPID करूथिबे होम डिपार्टमेंट
हाँ
मोस्ट लाइकली नहले पर्टिकुलर को गोटे डिपार्टमेंट हेतिबे जे डील करथिबो कि प्रोसिक्यूटर हेतिबे कि जदी आईओ जो डिपार्टमेंट रो
the home department.
मोस्ट लाइकली
Yes.
ताउते पार्टी करिवे ना आई कैन नॉट ऐड देम एज ए पार्टी ऑन माय ओन ना
And they have that.
दे हैव टू मेक इट तो सेटा से करिवे आउ कोन लेखले अपन लेखले Mr. The Lord Counsel for the petitioner submits that in absence of his leader due to personal difficulty, the matter may be adjourned. The Lord AGA submits that no department has been made party and copy has not been served, though state is mentioned as OP number 1. The Lord Counsel for the petitioner shall take steps to do the needful. Hala. Keep din pare?
2 weeks.
List in the week commencing 9/3/2026 अच्छी सफिशिएंट चलियो तेपनटा अच्छी 16 केतेटा अछि 37 टा ठीक अछि लिस्ट इन द वीक कमेंसिंग 16 3 यस ओके यस मिस्टर चक्रवर्ती
Item 6.
Here is a case where the husband was a victim of fraud.
अपीयरेंस पूर्वटा इलेक्शन डाक्टिल हां सीमा ठीक अछि ताकर पावर अछि तो एस चक्रवर्ती फॉर द पिटिशनर yes
Here is a case where the husband was a victim of fraud because the wife was mentally ill prior to marriage. That was the finding of the same judge in civil proceeding. I have annexed the judgment at Annexure 3. In spite of declaring the marriage void on the ground of chronic mental illness of the wife, again, the husband was directed to pay maintenance to her.
I mean, date of filing, date of order, sequence ଟା କଣ? File ହେଲେ
ମୁଁ କହୁଛି ଆଗ ସିପି ଫାଇଲ ହେଲା ସିପିରେ ଇଣ୍ଟରିମ୍ ମେଣ୍ଟେନାନ୍ସ ଆୱାର୍ଡ ହେଇଗଲା I was doing on paying interim maintenance. After 2 months of award of interim maintenance, she filed the criminal proceeding. During pendency of the criminal proceeding, CP were disposed of.
and while awarding 125, has the Lornet court taken note of
Yes.
interim maintenance?
Everything he had taken note of. Still then, he had awarded maintenance.
Acha, in CP, any permanent alimony has been awarded?
Yes, he has not awarded any permanent alimony, but taking into consideration the judgments of different Supreme Court judgments, as regards permanent alimony in 125, though the wife, even if it is what, wife is entitled to file an application under section 25 for claiming permanent alimony.
I mean, just again, one more clarification, as you have clarified almost everything. So the 125 order is after the declaration of the marriage?
Yes.
I mean, dissolution of marriage, not declaration.
A declaration of marriage are void on the ground of mental illness.
Date.
The judgment annex 3 date.
No. So obviously you are saying that 125 order is after dissolution.
We have discussed about that. And also the ground of
नहीं CRPC रे ex-wife अच्छी की वाट टा?
ex-wife was divorce. Wife includes a divorce wife.
सही सेंस से देचन.
से void टाको divorce करके देचन.
आपनकर केते अवार्ड हेछि केबेठु हेछि?
4000 टंका.
केते आपण जो दउथुले मेंटेनेंस
5000 दउथुल. से कते
दउथुले.
till disposal of civil proceeding.
डेट टा कोन तो
कोई नहीं. सिविल प्रोसीडिंग जजमेंट है 31/7/2025.
जस्ट वन्स 31/7/25 प्लीज. यस नेक्स्ट. तापरे आपनकर आपण केबेठु के जोउथुले?
फिर नोटटा मो पकड़े
आपनकर आरंभ केबे कले मेंटेनेंस टा?
आज्ञा
आपण मेंटेनेंस दबा केबे आरंभ करे?
सेटा इंटरिम में इतला से
सेक्शन 24 मेंटेनेंस देखिबे.
सेटा मो पाखरे तो नथियो.
ना अंदाज. तो कोचो ना 8000 केउथिले बोली.
गोटे जिंस कहिलो संगे संग कहले. तागर 125% टा मो पिटिशन फाइल ओवर 2 मास पर फाइल करछ. गोटे मिनिट में समीकरण करथि. सतर 6/24 2 मास पूर्व एप्रिल 24 मु दउची मेंटेनेंस
17/24 आपण एप्रिल 24 रो मेंटेनेंस देले.
देलछि इंटरिम मेंटेनेंस दी.
को जाय देले?
टिल डिस्पोजल
डेट
सीपीटा डिस्पोजल डेट देली क्या 31/7/2025.
31/7/25. सो ता माने आपनकर 5-6 मास जमा हिछि ए पर्यंत 25 रु ए पर्यंत जनवरी मिसेले भी 6 मास 7-5-12 31/7 माने 8-9-10-11
ऑफिस रो देई चलछि.
ना आपण कोन एबे दउछन या दउ नानु सेटा?
आ कहि देबी सीपीटा सरी गला.
सो आपण ए जो 125 टा जो 4 मास रे केतना लेखा अवार्ड करछन?
4000 टका अवार्ड करछन.
तो 4000 टका आपण 4 मास रे दियंतु.
नहीं सेटा करछन जी.
4000 तो ठीक थिबा आपण देखछन माने थिबो 4000.
4000 टका करछन जी.
सो 8000 टका जगह आपण 4000 टका 5 मास रे 20000 टका दियंतु नोटिस दियंतु.
नहीं 5 मास रो कहि नाथि पूरा देई चलंतु 4000.
बुझिले बर्तन पे देले सेटा नोटिस इशू हैला सेटा आसंतु से तापर देखिबा.
आज्ञा
आपण टिल नाउ 5 मंथ्स रे आपण को 4000 टका 20000 टका दियंतु तांकु.
आज्ञा
तापर से आसंतु तापर देखिबा.
ठीक है.
You have an arguable case actually. There can't be any two opinions on that.
मो सो सी आपण जो कथा अनुसार मो सी जजमेंट भी आनी 94 सुप्रीम कोर्ट कुलदीप जस्टिस ऑनरेबल जस्टिस कुलदीप सिंह एंड पीवी शर्मा फ्रॉड बीसीएस ऑल प्रोसीडिंग ता सही गोटा के धरि जाची.
नहीं इतने तो फ्रॉड है.
डेफिनेटली फ्रॉड गोटे गोटे पागल छे व्हिच वाज
बट द प्रॉब्लम इज हम सोसाइटी रे जो आपनकर मेंटल इलनेस इज डिफाइंड इन 13 केते जोटा दैट काइंड ऑफ इलनेस इज डिफरेंट.
एठी से आइची
एठी इन जनरल
एठी बदो कोर्ट जतले से एविडेंस दो
आपनकर नहीं कुड बी बट द प्रॉब्लम इज इट इज अ वेरी डिफिकल्ट ग्राउंड बिकॉज़ वन हैज टू ब्रिंग दैट टू द पैरामीटर्स ऑफ दैट.
एग्जैक्टली कोर्ट पटेले बोर्ड को
सो बोर्ड कहले कि जे
बोर्ड ओपिनियन यस शी इज chronic mental disease. She has no power to give valid consent. Even जेरा बेले मध्य तार डिमेनियर ऑफ द विटनेस कोर्ट मार्क करले से कोर्ट रे हसुर जंदी
valid consent माने मे बी आई मीन शी हैज अ मेंटल एज लेस देन हर एज. মানে গ্রোথ মানে নট অ্যাডিকুয়েট মেন্টাল গ্রোথ
মেডিকেল বুঝিପାରିବିନି
ভয়েড ম্যারেজ
ଇସ୍ ଭଏଡ୍ ମ୍ୟାରେଜ ଡିକ୍ଲେୟାର କରିସାରିଛନ୍ତି
କାହିଁକିନା ଆପଣଙ୍କର ଯୋଉଟା ଡିଫାଇନ୍ ହେଇଛି ଇନସାନିଟି ଆଜ୍ ଏ ଗ୍ରାଉଣ୍ଡ
ସେକ୍ସନ 12(1)
12(1) insanity has a limited nature as far as mental illness is concerned.
ଏଠି ଇନକ୍ୟୁରେବୁଲ ସେ କୋର୍ଟ କହିଦେଇଛନ୍ତି ବୋର୍ଡ
leprosy ବି ଅଛି but leprosy has now become cure.
ଲେପ୍ରୋସି ଦେଖୁନାହାନ୍ତି
ନାଇଁ ଆଜିକାଲି curable ହେଇଯାଉଛି
Curable
it is there.
କିନ୍ତୁ ଏଠି ଇନସାନିଟି ତାକୁ ବୋର୍ଡ କହିଲା
like insanity as a defense in a crime.
Yes.
It is not every insanity.
ସବୁ ଇନସାନିଟି ହବ ଠିକ ଅଛି ସେଟା ସେ ଆସୁ
Yes. So no instruction whether how much you have paid out of 4,000 per month 20,000 ଦେଇଛନ୍ତି ନା ଜଣା
ପଇସା ଦେଇନି
ଆଚ୍ଛା ତାହେଲେ ସେଟା ଦେଇ ଦିଅନ୍ତୁ
ଆମର ଏଠି
appearance lecture opposite party blank kindly take your seat I'll take 3-4 minutes to dictate. The petitioner husband is before this court seeking invoking the revisional jurisdiction under section 19 into bracket 4 of the Family Courts Act seeking revision of the order judgment dated 2011-2025 passed by the Lord's Judge Family Court Hon'Ble in CR.P. case number 34 of 2024. Completes full stop. By the said judgment, the petition filed by the opposite party wife in the marriage under section 125 of the section 125 of the CR.P.C. has been into bracket लिखिए
ବିଜନେସରେ ହବା କଥା 24 ବର୍ଷ ହେଇଗଲାଣି ମାନେ ବିଜନେସରେ ହବା କଥା କିନ୍ତୁ କରୁନାହାନ୍ତି ତ
since repealed and substituted by perimeter provisions contained in BNSS 2020. ଆପଣ ଏଟା ଯୋଉଠି ବି ଲେଖିବେ ସେଟା ଲେଖିବାକୁ ପଡିବ କାରଣ ଏଟା ନଟ୍ since repealed ମାନେ ସେଟା applicable ହବା କଥା ନୁହଁ କାହିଁକି ଲେଖା ହଉଛି ସେଟା ଲେଖିବାକୁ ପଡିବ ହେଲା the petition filed by the wife in the marriage ପୁରା କମ୍ପ୍ଲିଟ କଲେ ସେଟା ମୁଁ ଯାଇ ଗଲେ bracket closed was allowed thereby directing payment of monthly maintenance at the rate of 4,000 from August 2025 onwards, though the claim was for rupees 15,000. To substantiate the challenge to the said judgment, the learned counsel refers to the judgment dated 31/7/2025 passed by the said court, that is learned Judge Family Court.
And the PO was also said that. PO was also said.
No, I have marked that. This paperless has advantage. By click of a button, you see the page and passed by the court. And it Judge Family Court. Hon'Ble. The judgment lecture. Judgment. हाँ 25 in CP case number 84 of 2023. Hello. The said CP that was filed by the present petitioner husband in the marriage under section 12 into bracket 1 into bracket English small b read with section 5 into bracket Roman small 2 of the Hindu Marriage Act from 1955 and section 7 of the Family Courts Act seeking annulment. It was a declaratory relief.
Yes.
Or
to declare the marriage null and void.
seeking
That was also declared.
for declaration of the marriage to be null and void that was solemnized between the petitioner husband and the opposite party wife on 25.01.2023 on the ground of insanity, quote unquote, single quote, insanity suffered by the language that one like go to second. वही पड़ेगा
Will one be, any marriage shall be voidable and may be annulled if the marriage is in contravention of condition.
language used is type 2 record insanity में कौन लिखा है used
नहीं सेठी लिखिले
अरे on the ground of कौन लिखले insanity में IP शुरू पड़े इसमें unsoundness of mind quote single quote unsoundness UNSOUNDNESS of mind oblique mental disorder है ना तापर एक quote ends single quote index complete stop full stop the CP was allowed by the judgment declaring the marriage between the parties null and void. It is submitted that during pendency of the said CP, interim maintenance was directed to be paid by the learned court, which was paid from April 2024 till July.
July.
Till disposal of the CP in July 2025. The CRP was filed during pendency of the CP on 18/6/2024 and has been decided and has been disposed of on 20/11/2025. It is submitted there. सेटा से आपनकर डिक्लेरेशन ऑफ नॉलिटी टा कंसीडरेशन को नहीं चलते ना बिल्कुल ले लेनी
हां सेटा जजमेंट सब नहीं चल
it is submitted that the learned judge family court erred in its conclusion having taken note of the judgment declaring the marriage null and void in awarding monthly maintenance under section 125 CRPC. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 7 working days. Returnable date be fixed to 19 March 2026. List in the week commencing 30 March 2026 है ना तापरे आइए 4 of 2026 the IA has been had learned counsel for the petitioner. He reiterated his submissions as noted above in assailing the order assailing the judgment. Issue notice as above. Requisites for
One set of
accept, one set of process fee as well as postal requisites be accepted as directed above. The subject to the petitioner depositing before she କେମିତି ନଉଥିଲେ 8,000 ନା 4,000 କେମିତି ନଉଥିଲେ?
ସେ କୋର୍ଟରେ ତ କେସ୍ ଥିଲା କେତେ ନେଇଯାଉଥିଲେ ଆକ୍ଚୁଆଲି କୋର୍ଟରେ କେସ୍ ନାହିଁ ତା ଆକାଉଣ୍ଟ ଖୋଜିବାକୁ ପଡ଼ିବ
the petitioner shall credit rupees 4,000 into 5. That is from month of କେବେଠୁ ହେଇଥିଲା ଏଇଟା ଜୁଲାଇ
ଅଗଷ୍ଟରୁ କହିଥିଲେ ଅଗଷ୍ଟ ସେପ୍ଟେମ୍ବର ଅକ୍ଟୋବର ନଭେମ୍ବର ଡିସେମ୍ବର 5 ମାସ
ହଁ August for the month from August 25 to December 25. August September
ଅଗଷ୍ଟ ମାସଟା ଆରମ୍ଭ ହବ ଏଇ କାଟରୁ ଅଗଷ୍ଟ ସେପ୍ଟେମ୍ବର ଅକ୍ଟୋବର ନଭେମ୍ବର ଡିସେମ୍ବର 5 ମାସ
5 ମାସ ନା 20,000
without
prejudice to her rights and contentions
his rights
to the raised in the present case. The amount shall also be accepted by the opposite party without prejudice to the rights and contentions. The ତାପରେ subject to ଦେଖିଲେ ନା କଣ ଆରମ୍ଭ କଲେ ସେଣ୍ଟେନ୍ସ କଣ ନା ସେଟା ହେଇଗଲା ତାପରେ ଲେଖନ୍ତୁ ନେକ୍ସଟ ପାରା ସବପାରା କରିଦିଅନ୍ତୁ subject to payment of the above amount the operation of the interim judgment dated dash past in dash dated 20/11/25 past in criminal proceeding number 34/20/24 by the learned judge family court Hon'Ble shall remain stayed till appearance of the parties. If after a sir liberty to till next date of hearing till next date of hearing list after a sir liberty to mention
ମିସ୍ ସିହ୍ନାଙ୍କ ନାଁଟା ଟିକେ
yes Miss Tapaswini Sinha
ତାଙ୍କ ନାଁଟା ରଖିନି ଲିଷ୍ଟ ଆସୁନି କାହିଁ
Miss Tapaswini Sinha who name of Miss Tapaswini Sinha shall be mentioned in the cause list as well as the first case brief ଦେଖି ଦଉଛି ଅଛି କି ନାହିଁ
ହଁ ପାୱାର ଅଛି
ନାଇଁ ସେମାନେ ବେଳେ ବେଳେ କଜ ଲିଷ୍ଟରେ ଭୁଲ ହଉଛି
ଆଜ୍ଞା
ସେମାନେ ତାକୁ ଦେଖିକି ବାଡେଇଲା ବେଳେ ଯୋଉ
ଆମ ଅଫିସ ମାଲିକଙ୍କ ନାଁ ଛାଡିକି ଆମେ କେମିତି କର୍ମଚାରୀଙ୍କ ନାଁ ରହିବ ଯାହା ମାଲିକଙ୍କ ନାଁ ରହିବ ଏଇଟା ଖାଲି ମୋ ସିନିୟର କ୍ଷେତ୍ରମଲ ମିଶ୍ର ବୋଲି ତାକୁ ଆଗରେ ଅଛି ତା ପରେ ପରେ ଅଛି ସିହ୍ନାଙ୍କ ନାଁ ଅଛି କ୍ଷେତ୍ରମଲ ମିଶ୍ର
ସିହ୍ନା ଅଛି
ନାଇଁ କ୍ଷେତ୍ରମଲ ମିଶ୍ରଙ୍କ ପରେ ପରେ ତପସ୍ୱିନୀ ସିହ୍ନା ଅଛି ଦେଖିଦେଇଛୁ ଲେଖିଲେ ଅଛି
ହଁ ହଁ ସିଗ୍ନେଚର ବି ଅଛି
ହଁ ହଁ
ରାଇଟ ରାଇଟ ସେ ଯେହେତୁ ଟାଇପ ହେଇଛି ଦେ ହାଭ ମିସ୍ଡ ଇଟ୍ ଆପଣଙ୍କର ଟାଇପ ହେଇକି ଅଛି ସେ ହାତ ଲେଖାଟାକୁ କରିଛନ୍ତି
ଆଜ୍ଞା
Miss Tapaswini Sinha shall be MS. Tapaswini Sinha shall be mentioned in the cause list as well as the case brief as she has filed Okalatnama at the lead counsel. As the lead counsel, ସେ ଯୋଉ ପଢି ପାରୁନାହାନ୍ତି ଆପଣ କେମିତି ବୁଝେଇବେ ତାଙ୍କୁ ସେ ନ ପଢିକି ସେମିତି ଟାଇପ କରୁଛନ୍ତି ୟେସ୍ ଆଜ୍ଞା ଆପଣ କେତେ ଚାହୁଁଛନ୍ତି ଦେବା ପାଇଁ 15 ନା 25 କେତେ ଆପଣଙ୍କର କଣ ମତାମତ ୟେସ୍ ପଚାରିଲେ ସାର୍ କଣ 20,000 ୟେସ୍ ନେକ୍ସଟ
Item 7. No, item
B Mahapatra for the petitioner.
Petitioner is the wife, my lord.
Yes, please.
She has filed this application for transfer of CP case number civil proceeding number 353 from the court of Joint Judge Family Court Jajpur to the court of Joint Judge Family Court Cuttack. And she has a 3 years kid of 3 years old, and she has no independent income. She's staying with her father, with his father. And
I mean, the CP is filed for what, sir?
CP is for the divorce, my lord.
Again, divorce.
Divorce and
by the husband.
By the husband, opposite party. And she has filed a 124 petition, 144 VNSS for maintenance in the court of Judge Family Court Cuttack, my lord. Under Annexure 1, my lord.
Take notice.
And she has no mailman to accompany with her to go to Jajpur. And Jajpur is quite 81 kilometers.
Okay, you take notice. Right now, no special. You take your seat, I'll dictate down sometime. The petitioner has the petitioner wife is before this court seeking transfer of the CP number 353 of 2025 pending before the learned judge, Family Court, Jajpur. The said CP has been filed by the husband in the marriage under section 13 into bracket 1 into bracket IA, Roman I English small a, bracket closed, into bracket I small b, the Hindu Marriage Act, 1955, seeking a dissolution of marriage solemnized between the parties on 7.505.2019 at Tangi in the district of Cuttack. Had learned counsel for the petitioner, appearance like Chandita. Stop. He submitted that the petitioner wife, who is the opposite party in the before the learned judge family court, is distressed. She has to fend for herself, staying with her parents at Tangi, Cuttack. He submitted that in the interest of justice, the matter should be transferred to the learned judge family court, Cuttack. CORAM. If you notice along with this order, requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 days, 7 days?
Within 7 working days.
Within 7 working days. List after SR, liberty to mention. The returnable date be fixed to 18 March 2026. The IA 3 of 2026. Hard learned counsel for the petitioner. He reiterated his submissions as noted above. Issue notice as above. One set of process fee as well as postal requisites be accepted along with the petition. The CP number so and so, pending before so and so, shall be adjourned beyond returnable date kebe kalo? Shall be adjourned beyond 30 March 2026. As would be convenient to a date convenient to the learned court in season of the matter. List after SR, liberty to mention.
Stay further question stay.
खराब हो जाउची स्टे कले आपण सेठी अपियर करू नांती आपनकर पेंडेंसी रो रीजन होची
She has no independent.
the entire matrimonial disputes family disputes have lost its direction
Third one is that income which is jiba
sir कटक रे बिना पैसा रे हबनी प्रोफॉर्मा पपर्स इज एवरीवेयर कटक रे भी पैसा पड़िबो जाजपुर रे भी पैसा पड़िबो दैट इज आई हैव नॉट रिटन दोस थिंग्स it is illogical on transfer he pare ठीक अछि but now the TRP is the method of stalling the process of adjudication and there will be genuine cases like maybe in your case is
Item 8.
अपन adjournment और stay भीतर तफात कौन अछि इस तफात ना अपन उकिल एंगेज करिया कथा
May I please, Your Lordship?
yes please
If the petitioner, Your Lordship, is the wife,
yes
she has challenged the order, rejecting her application under Order 9, Rule 13 for setting aside the ex parte order, Your Lordship.
order 9 rule 13 हाँ order 9 rule 13 टा अपन इग्नोर किया हो
Again, last occasion, Your Lordship has been pleased to take instruction whether it will be read or appeal, Your Lordships. Under Section 19 of the Family Courts Act, this will be appeal, Your Lordship. I have filed a
so it will be sent for I mean
conversion, Your Lordship.
conversion or go to the staff report
Conversion.
staff report na staff reporting conversion तो ही पर It has to be gone for
I
stamp
have
report.
filed an IA 2958 of 26
Okay.
for conversion, Your Lordship.
But you should have waited for the stamp report because that is the basis of conversion.
That light
I think
judgment
I have
is
not directed for stamp reporting.
judgment is also there.
Mr. Vivekananda Jena for the petitioner. The learned counsel for the petitioner refers to the order dated 22.01.2026, paragraph 3, paragraph 2 and 3, and submits that. Apart Family Court Act कहले ना?
Under order 43 rule 1 also, it is an appealable order.
He refers to order 43 rule
Read with section 19(1) of the Family Courts Act.
as well as section 19(1) of the Family Courts Act to submit that the appropriate remedy would be a appeal before this court in the form of MATA stuff. Accordingly, the matter shall be placed for
Judgment
reporting again to enable the petitioner to move the application for conversion. Conversion by दे दी चंदी, which has already been filed.
IA number
IA number कौन है? Application for conversion
2958 of 26.
into bracket लिखी देवे. IA number 2958 of 2026. Yes.
Item 9.
I will file the
Ready to do the needful. अपन एटा स्टाफ रिपोर्टिंग हेला जाएगी फिर आता लिस्टिंग आपको आसो.
I will file the consolidated.
नहीं वो तो अलाउ करनी ना मु करी परिबे ना अलाउ because स्टाफ रिपोर्टिंग हेला पर ही मो पाकु जदी आसीओ I will allow that.
Next week, Your Lordship.
ठीक अछि. Next week हेई परिबोनी. आपनकर वीक कमेंसिंग 23 रे कोटा कोना लिस्ट इन द वीक कमेंसिंग
Any day.
it is also difficult. In the week commencing 23 week 26. So आसीबो.
Item 9.
May it please, Lords, this is a petition challenging the order dated 1811.
Sir?
Advocate Rahul Pradhan. Rahul Pradhan. Rahul Pradhan. Yes,
So
Lord.
Rahul Pradhan for the petitioner. Yes.
Lord, this is a petition.
Pradhan, you take your seat. You will take yours. Yes.
This is a petition challenging the order dated 1811-2025 passed by the Learned Civil Judge Senior Division under Section 24. My Lords, the annexure is placed at Annexion 8, running page number 90, my Lords.
Yes, please.
The challenge for the petitioner here is because
90 you are referring?
yes, my Lords.
Yes. Yes.
The challenge here, my Lords, is on 4 grounds. The first ground being under Section 24, the application can be made by either of the spouses. If your Lordship may grant it, if your Lordship may kindly see at page number 83, that is the impugned order. The first page it's written, it's it's not just the mere spouses, it's also the children of the spouse. Now, my Lords, as per Section 24, it's clear it is just the either of the spouses. To that effect, I'm also citing
25 also.
25 also, my Lords.
So in which case, have you read any idea of in which case the husband has got substantial 25?
My Lords,
Not here in India also.
my Lords, I'm not aware. my
There
Lords.
are cases
But my
where the husbands of rich wives have got 25 and 24 orders. Similar. It may not be a Hindu marriage act. I'm saying about the general concept of
No, look, sir, my contention is that when there's another provision which allows one of the children to file for the maintenance, then the subsequent petition with the 24 is allowing just the spouses and 26 is allowing the children of the spouses to seek before your Lordship's the maintenance.
Can
Then
we kindly place that provision?
26 millards.
No, first you start with 24.
24 millards. Maintenance, pendant, light and expenses of proceedings. Where
Yes.
in
Read. Yes.
where in any proceedings under this act, it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the proceeding, it may, on the application of the wife or the husband, order the respondent to pay the petitioner the expenses of the proceeding and monthly during the proceeding such sum as, having regard to petitioner's own income and income of the respondent, it may seem to the court to be reasonable.
Yeah.
Now, Milords, may kindly see at page
26. No.
26, Milords.
Yes.
Let me read
Yes, you
section
complete
26.
reading that section.
Your Lordships, this starts with custody of children. In any proceeding under this Act, the court may, from time to time, pass such interim orders and make such provisions in the decree as it may deem just and proper with respect to the custody, maintenance, and education of the minor children, consistently with their wishes, wherever possible, and may, after the decree, upon application by the petition for the purpose, may make from time to time all such orders and provisions with respect to the custody, maintenance, and education of such children as might have been made by such decree or interim orders, in case the proceeding for obtaining such decree were still pending, and the court may from time to time revoke, suspend, or vary any such orders and provisions previously made.
Yes.
So my contention here is before your Lordships is that
Then can you complete the proviso? Reading 26 proviso, just read also. Or anyway, if you're not getting that proviso in your book, so you come back to your, always try to have that 20 rupees book. The cost has increased. But this impact, reading a small book, which we used to, as a barrack, it was then available for, even some barracks were available at 15 rupees.
Milos, I will carry that next time.
So that becomes easier.
Yes, Milos.
Yes.
So that is my first submission, Milos.
Submission is, like, I could not get that.
The submission is, Milos, my submission is, if an application is made under Section 24, it has to be either of the spouses that is making the application, not the children. When the law provides under Section 26 that either of the children can make an application.
No. The application part, kindly find out where.
Section 26.
There I am not agree. I don't.
Lordship, to that effect, I'll cite before Lordship the Law Commission report.
Not law commission, sir, that will be difficult. I cannot go to law commission report because it's an enactment. 26. You are saying 26 has to be, a petition has to be filed by the child.
Yes, my lord.
So which line you are reading that? That I want from.
Lord, that is second line, my lords.
Yes.
It's written, as it may deem just and proper with respect to custody, maintenance, and education of minor children, consistently with their wishes. And secondly, it's upon application by petition for the purpose.
Sorry?
And it's written upon application by petition for the purpose. So 26 mandates.
So why do you say that children will apply? Because children need not apply.
Will see
the immediate guardian who is having custody, he will apply. He or she will apply. It may be father. It may be mother.
To that effect, the clarification has been provided by Law Commission report.
To this law commission cannot clarify. You examine the law on this. Law Commission report has to be read not along with the statute. Statute has to be read independent of the Law Commission report. But to interpret a statute, one can take help from it. But what is the objective? Purposive interpretation.
To that effect,
now in a case, even the child doesn't make an application, but the mother says that, like, coincidentally, I have heard a petition where the mother files the maintenance application for the child in the womb from the marriage. I have delivered that. But the date of delivery of the order, the child is already born. Then how the child will file the application? So it will be represented by suppose a newborn child is left with the father, the mother leaves the child. Then obviously, and the father wants maintenance from the mother. So he'll file an application stating that the child is with me and I have to maintain the child and these are the expenses. Medical expenses, food, clothing and other necessary expenses. Immunization of a child, all these things, expenses, medical expenses, health needs. So for that, application by the child is not necessary.
But Milot, sir, to this effect.
And if it is necessary, the statute is very clear, it is not required. Then how do you compare? What is the interplay between 24 and 26 you are saying? My
contention here is before your lordship is that only the spouses, if we clearly apply the statutory understanding of 24 and 26 is there. There is a reason why 26 is there, because under 26, the child can, under the law, child can go for its maintenance. So when the 24 has been there, 24 section 24 is there, the children is not been mentioned. It just clearly says either of the spouses, my lords.
Both.
To that effect, my lords, there is a clarification as per the Law Commission report.
No, statute
Clearly says that as per Law Commission report,
cannot-
your lordship may kindly read the Law Commission report for your lordships.
Before I'm really kind to read, no problem. But you have to be kind to tell me that Law Commission report has to be read with the statute. That citation you have to.
Your lordship, the clarification of 24 and 26 is given.
They cannot. They do not have any legislative competence. They do not have any legislative authority. They have no business to. Only courts can interpret. They do not. They lack the judicial capacity also to interpret a statute. Law Commission reports, you have to. There are case laws on this. At least I have read. To what extent the Law Commission reports can be read to interpret a statute. Anyway, suppose let us assume that Law Commission. Let us assume which is an impossibility. According to you, as per the Law Commission report, what is to happen?
That if the petition by the child, the child should not be made as a party as under section 24, my lords. The child cannot be made as a party. So that is a wrong joinder of the party, my lords.
Why not? My
lords?
Suppose a petition makes a child as a party and only mentions 24. There is ample case law on this that mere citing of a wrong provision does not frustrate any application. Several decisions.
So, my lords, so this
now what according to you is the flaw in the judgment? Because child is made a party.
My lords, let me clarify. This is just one of the grounds, my lords.
No. Ask, what is that ground you are saying that along with in the 24 petition, child is made a party?
Yes, my lords.
So, but you have, then you read that. 23A you read.
My lordship?
23A, capital A.
Relief for respondent in divorce and other proceedings. Relief for respondent in divorce and other proceedings. In proceeding for divorce or judicial separation or restitution of conjugal rights, the respondent may not only oppose the relief sought on ground of petitioner's adultery, cruelty or desertion, but also make a counterclaim for any relief under this act on that ground. And the
Can you stop there?
Yes, my lords.
Any relief under this act? Can I read it again?
In any proceeding for divorce.
Yes.
In any proceeding.
No, not that, sir. Just you where I stopped you. But also make a counterclaim for any relief under this act.
Your lordship is a counterclaim, my lords.
Yes. So even then can you read further? Relief under this act. So what is the relief under this act? It can be 24, 25, 26. Then kindly read.
And if the petitioner's adultery, cruelty or desertion is proved, the court may give the respondent any relief under this act to which he or she would have been.
No, that is not relevant. So I wanted to tell you that, show you that any the word any relief.
Yes, my lords. I understand you.
So this has you. Then you have to read why the Law Commission report on this. Because this law commission report on 24 or 25, you are referring 26?
There's a Law Commission report from 24 to 26.
24 to 26? Yes. Dated?
Dated it's 98th report from section 24 to 26, April 1984, my lords.
1984?
Yes, ma'am.
So they suggested some changes.
No, my lords, they're not suggested. They just clarified the position, my lords. It's written clearly, my lords, if I may read it out. Lordship's for convenience, I read it out.
No, not convenience. For my convenience, don't read it wrongly.
It's written. First.
Parliamentary power is not which is the legislative competence to enact these laws? In Constitution, which articles provide the power to legislate? And to whom?
Legislator only does, my lords.
Yes, but it is defined. It is very clear.
Passes in the
It is very clear in
Lok
that.
Sabha and then Rajya
You
Sabha.
have constitutional law in your, I mean, as a subject,
Yes,
as a
ma'am.
student of law.
Yes.
I continue as a student of law, but you had constitutional law, so
Yes,
you
ma'am.
must remember those articles. Subject matter competence, more hint. Territorial competence, which articles? You will find there is no concept of any legislation or clarification by this law commission. There is no competence.
Lots, ma'am.
You clarify any statute, then 245, 246, you go through 245, 246, articles 245, 246. Constitution code. ବହି ଅଛି ଆପଣଙ୍କ ପାଖରେ ଆଉ ବହି ଅଛି it reads relations between the union and states 245 part 9 part 11 chapter 1 legislative relations distributions of legislative powers. Here from 245 to 255 there is no reference to anybody other than the legislature. We are a parliamentary democracy, either it is the state or the union.
Lots, I understand.
These things they are done, they do research that regarding implementation of these laws and what better if any enactment is to be brought or any amendment is to be brought.
Lord, this is just one of the grounds. The second ground that I'm coming to, Lord.
So if you read that, no, because why you are making the first ground, I am unable to follow actually. When you examine if the law commission has given a report.
Yes, no, that's a 90th report, Milords. I've downloaded from the Law Commission of India website.
So can you read chapter 7 recommendations? Then you will get it. What I am saying is there. I'm simply, it's a coincidence that I have discovered it what I am telling you. Read the recommendations. From the top.
Yes, my lords. In the light of what we have stated in the preceding chapters and having
to come back, I have already.
Yes. The second ground being.
No, let us come back. I have already exceeded. I have other work to do. Our time is. We appear to be free, but it's not that.
Amendment 27. It is regarding the payment of the pension and
Let us see.
my lord, it may not reach, my lord.
Let us see if it reaches. Otherwise, it will be listed some other day.
I can be only
It will be-
counted to be received, my lord.
2 weeks.
Only counted to be received, my lord. That's why I'm telling you.
So the petition of payment, counter has not been filed by the state company or the accountant. Notice has been issued, and some notice has been not sufficient as indicated in the list.
No, all received it. Last time also applied.
No, but
But earlier,
No. ଆପଣ list ଟା ପଢୁନାହାନ୍ତି.
list policy.
ହଁ, so ଲେଖା ହେଇଛି 8 copies of proof not served on counsel for assembly.
This is a wrong concept, my lord. I have later filed 3 copies extra. I have got this.
That is not a matter of talk about stocks. I believe you. He also believes you. What the registry perceives, that is important. I cannot supersede the registry. Suppose ଆପଣ ଯଦି ଫାଇଲ କରିଛନ୍ତି ମେମୋଟା ଦେଇ ଦେଇଥାନ୍ତେ ସରିଲା ଆପଣ ଯେବେ ଫାଇଲ କଲେ ସେ ମେମୋଟାକୁ ଫାଇଲ କରିଦେବେ କି ରେଫର କରିଦେଲେ କୋର୍ଟ କରିଦେବେ
I got to receipt, my lord, here. I have not filed in the registry.
Let the matter reach. Allow us to go ahead with today's sir.
My lord. My lord, the only point is they have to file the
Sir, I
counter.
cannot prioritize cases.
No.
No priority for any cases out of term hearing. Please appreciate. If I am reaching, I will take
It is
it.
already notice has been issued, my lord. The only point is that
cannot
the
be-
counter 3 years past, my lord.
That cannot be a ground for taking up the matter out of term. जो डेट चाहिए सर आर्जनमेंट मेरिट कौन शुणा दरकार और जो डेट कहिबे से डेट रखिदबा नेक्स्ट वीक ता पर वीक छाड़ दियंतु there will be disruption because of the other engagements
26, my lord.
26 को करा फेब्रुआरी
26 February.
नहीं से वीक तो छाड़ दियंतु नेक्स्ट वीक ता पर वीक छाड़ दियंतु आपण मार्च मास
All right, my lord. For the counter purpose, etc., I'll pray appeal second week or third week.
एप्रिल जाउछंती
April third week.
ठीक कर दियंतु
नहीं, 6 नहीं. टिके आगु को second week. 13th, 20th April.
वी कमेंसिंग 20 एप्रिल
My lord.
ठीक अछि कर दियंतु
ତା ଭିତରେ ଖାଲି କାଉଣ୍ଟରଟା ସମସ୍ତେ ଦେଇ ଦିଅନ୍ତୁ ସେଟା ଟିକେ ଆକ୍ସନ
ସେଟା କଣ କରିବା ସେ ତ ଦଉନାହାନ୍ତି ଗୋଟେ
ନାଇଁ 3 ବର୍ଷ ହେଲା ଦେଇନାହାନ୍ତି ତ ସେଥିପାଇଁ ମାଇନର୍ସ ୱାର୍ଡସ୍
କରେକ୍ଟ
ବହୁତ ଆପଣ ଖାଲି କହିଦେଲେ ସେ ଦେଇଦେବେ ଆପଣ
ମୁଁ
କହିଲେ ଆପଣ ଦେବେ
I am confident of that. Anyway, let us see.
ନା ଆପଣ ଖାଲି କହିଦିଅନ୍ତୁ ଗୋଟେ ଖାଲି କାଉଣ୍ଟର ଫାଇଲ ଲାଇନ ସାବ
Yes. ठीक ଅଛି ये जो मिस्टर प्रधान करे अपन मैडम कोन
My lord, item 18 has become infructuous.
मेमो दियंतु से अपन को नाम मैडम
Shakuntala Ghosh.
शकुंतला
Ghosh.
घोष on behalf of
Mr. Susan Kumar Nath.
सिग्नेचर किए कले मेमो रे किए करचंदी
Susan Kumar Nath.
करचंदी ठीक अछि बता ना ब्रैकेट रे लिखि दियो डोंट साइन ए मेमो वेयर यू आर नॉट ए पार्टी स्पेशली विथड्रॉल्स हैला अपन जो सॉरी अपन जो वेयर यू आर नॉट ऑन रिकॉर्ड नॉट पार्टी में भूल कहि देली you must represent the client to withdraw an application. Correct? Yes. Memo नियंतु आया 18 disposal. Say last टा पढ़ंतु recommendation. Then you will get what I am telling you.
I have one.
Article 245 246 पढ़ंतु recommendation.
Article 245.
Recommendation of law commission टा पढ़ंतु. Last page रे अछि.
Madam,
Recommendations.
Recommendation, in the light of what we have stated in the preceding chapters and having regard to the problems that have arisen with regard to one, the question whether a formal application for interim maintenance under Section 26 Hindu Marriage Act is needed, the date from which an order for interim maintenance for spouses or children can take into effect under the Act, we are of the opinion that it is
slowly. We are of the opinion
that it is necessary to amend the Act on
enough. So who will amend that?
that is the government laws.
Yes, not government.
Legislature.
Opinion is given by so that is not even binding on the legislature also. Please appreciate that. That is not even binding. So law commission reports is they review and they come out with real time excellent suggestions. But it will be the legislative wisdom and prudence whether to act upon that. So it remains opinion. It will continue to remain as opinion that you cannot relying on, because the courts are only looking at the statute.
My submission was
So whatever the statute is, you have to read it. Now the problem is that what is the disadvantage of reading or advantage? Advantage of reading Law Commission report, you get a broader perspective. Disadvantage is that your thought process gets diluted. Instead of concentrating on 25, 26, 24 as it is, you start thinking about the Law Commission.
no, my humble submission.
That if you are saying that since the Law Commission has suggested this, you will articulate on that, it has to be rejected outright.
No,
This is the subject matter of judicial consideration. Correct.
Yes, my submission was
And also examine whether the court can issue directions to legislate.
no, that that is judicial overreach, that may be.
So you know the answer. Then. The Constitutional Court cannot
direct It
When
was just
then Law Commission, who is Law Commission? So it will be an opinion because they have a responsibility. Working of the law, they consider how it is working.
Yes, my lords.
And these suggestions, they are taken into court gradually. After some time, they are taken into court.
That is understood.
But say example, irretrievable broken down.
Yes, my lords.
It has been suggested by Law Commission, suggested by a High
It has
Court.
not been taken. Yes,
Yet the legislature has decided not to
consider it.
Recently in POXO, Romeo Juliet clause, Supreme Court has suggested it has to be there.
Yes,
otherwise it results in gross, violation of rights of an individual child at times.
Yes, my lords. Yes, my lords.
But please mark the response of the state before the Supreme Court. State is very clear in its say that it will dilute the protection granted by the said act. It cannot be done. So state, obviously there is a clear-cut distinction. Judicial overreach.
Judicial overreach, my lords.
So the same thing cannot extend to legislative also. Legislative exercise of legislative to enter into legislative domain. Actually, it's not.
Let's see.
It's not a happy situation. But what is your point? What is your point on this?
My point was simple. As
you are referring to the Law Commission report.
My point was that if the child wants to be a party, they cannot be a party under 24 because this law strictly declines them to be a party. They can choose the section 26 millards, which can be adjudicated before the family.
The child wants to be a party. The child will be represented.
That is represented through 26 millards that the law provides under 26 millards.
So you are agreed by a particular portion of the order.
No,
Yes.
Okay, you read that. You read that.
The order millards 83 page millards.
Yes.
My submission from the first issue was that the party that is asking.
No, the problem is that if you start with your submission,
no,
then again your thought process will be diluted. You start with which part you are challenging or which part you are targeting.
Yes, my lords.
Yes.
The first issue. The issue is, my lords. Page number 90, my lords. 90. Let's the IA has it's written clearly. If I read it out, accordingly, respondent is directed to pay a sum of rupees 40,000.
Yes.
Now, my lords, in the entire judgment, in the entire order, the learned trial court, that is the civil judge senior division, has failed to adjudicate as to how they have come to a conclusion of 40,000, my lords. Like on what grounds? Where is the issue on? Because in the entire order itself,
can you read para 5?
Para 5.
Then you will get the reasons.
Heard counsel from both respective sides on verification of case record vis-a-vis the documents on record. It is seen that the petitioners have filed original MAT case for restitution of conjugal rights of the petition number 1 with respondent. It is pleaded by the petitioner that the respondent deserted petition number 1 without any just cause, which is stoutly denied by the respondent in his counter, who has alleged that it is the petition number 1 who has voluntarily withdrawn herself from the society of her husband since 9/9/2021. Hence, the disputed question relating to alleged desertion is a subject matter of the adjudication of the main MAT case, and no conclusive remark to that effect can be given in the interim application. But it is an admitted fact that the petition number 1 is the legally married wife of the respondent, and the said fact is also admitted by the respondent in his counter. It is further admitted by the respondent that they were blessed with a male child on 24/10/2018. It is asserted by the petitioners that the respondent is working as a software engineer in a multinational company and earning 40 lakh per annum. 40 lakh per annum. To that effect, the respondent has filed his assets and liabilities, wherein monthly income is mentioned as 1,69,199. Additionally, respondent has filed a list of documents including payslip for the month of April 2025, which goes to reveal that his monthly gross income is 2,16,908, and after deduction, he is drawing 1,69. It is contended by the respondent that the petition number 1 is a highly qualified lady for which she can maintain herself. But Milords, if I may clarify,
No, don't clarify any judgment.
No, I'm not clarifying, Milords.
Okay, Milords. Nobody is asking for your comments on the judgment.
Yes. It is contended by the respondent that the petitioner number 1 is a highly qualified lady for which she can maintain herself. But there is absolutely nothing on record to show that the petition number 1 has an independent source of income. In this regard, the learned counsel for the petitioner during the course of argument relied on decisions of the Honorable Apex Court in the case of Rajneesh versus Neha and others, Reena Kumari versus Dinesh Kumar Mehato, the Manish Jain versus Akansh Jain, Selja and another versus Khobana and Bhuban Mohan Singh versus Meena and others, and a decision of the Honorable Delhi High Court in cases of Sikha Badlani and Hemant Badhani and Praveen Kumar Jain and Anju Jain, and submitted that the educational qualification of the wife has nothing to do with the grant of maintenance, and the court must take into consideration the status of the parties and capacity of the spouse to pay for his or support. It is also submitted that the test for determination of maintenance in matrimonial disputes depends on financial status of the respondent and the standard of living that the applicant was accustomed to in her matrimonial home. In the case at hand, it reveals from the assets and liabilities of the petitioner that the petition number 1 is an MCA degree holder, but nothing on record to show that she has any independent source of income. Admittedly, petition number 2 is the minor son of the litigating parties, who is aged about 7 years. On the other hand, the respondent is a salaried person having sound source of income, and law is well settled that a husband is duty bound to maintain his wife and the minor children. It reveals from the case record that the evidence in Matt case is yet to begin, and as such, it might take some time to finish the proceeding. In the meantime, the petition number 1, who is staying at a parental house with a minor son with no source of income, needs some maintenance for herself as well as her child during the pendency of the Matt case. The order, the IA.
So now, this is the reasoning portion.
Yes, my lords.
So now, why do you say that there is no evidence?
No, my lords, the CV of the wife, that is the respondent.
CV, according to CV,
she was employed at some point.
So what is the proof you have to show? How you have proved it? What is the cross-examination? What was your questions to your wife to disprove her claim regarding maintenance? I hope you are there when I was discussing
yes, my lords.
The Honorable Chief Justice Deepak Misla's judgment. Because the language is very simple rather, and also very emphatic.
Milords,
so now suppose you have adduced evidence.
Yes, Milords.
And the court has not taken care of that. You straight away come to your evidence. How you have dislodged the claim?
Milords,
because if you are saying that the CV says that CSE, PhD, gold medalist, all these things, that is not a relevant consideration. Because 24, whether you have deserted or she has deserted, 24 is not it can't be adjudicated because 24 doesn't leave any scope. If there is any scope, that should be your argument. Then 24 says that so and so is provided. So in case of desertion by the wife, it is not maintained. But for that desertion to be proved, you have to go again back to the evidence.
Yes, my lords.
And 24 doesn't entertain that because 24 now kindly read 24. There is a major difference between 24 and 26. I was waiting for you to comment on that. But since you have not said, 24 is actually pendentalized.
Yes, my lord.
26 is anytime.
Anytime, my lord.
After disposal. So now, if you if you take then you have to find out actually where the court has erred. You have to go through the evidence, because it is not a matter of argument or speech that, like a writ petition, that you are filing documents, they will file counter. Still, there is some matter of I mean, pleadings have to be there, supported by documents in writ petition. But here it's a case of pure evidence, and within parameters of 24, nothing beyond that. And this is regarding maintenance during the litigation. Suppose now you lose the litigation of divorce. Who has filed divorce? Or 9?
Section 9, wife has filed.
Wife has filed. 13, have you filed?
No, my lords, we have
So
not.
there is no other litigation during pendency of section
My lords,
9.
there is a GR case pending against the husband.
Okay. So section 9 for restitution. So now section 9 is pending. Section 9 is dismissed. Will that impact 24?
No, my lords,
It will not.
It will not impact.
Section 9 is allowed. It can never impact. So in fact, pendency of a litigation, section 24 is pendentalized. That means pending litigation. So you have to show something to the court where the court has erred in appreciating the evidence.
My lords, that is the whole issue, my lords. That 40,000, my lords.
I mean, it can't be a matter of speech, because the calculation is very simple. The court is very liberal towards you. 25% is High Court direction. Out of 2,70,000, suppose you
My lords, actually,
suppose you
in hand cap.
you have to hear, then it can register in your mind. Or if you know what I am saying, then you tell me. I have no difficulty in listening from you. But do you know what I intend to tell?
Yes, my lords.
2,70,000, how it is reduced to 170, it is not there. Court should not have.
That is the in-hand salary, my lords, from
You are not
the salary
getting the point. Nobody is asking you to explain the salary. When the court has evidence that it is 270 and it reduces to 170, it has to give reasons. No reasons given. You can't supplement the reasons, enhance salary, all these things. It has to be right. The reasoning should be there. Suppose now you invest in Bitcoin every month, 2,70,000. What will be your salary? 0. The maintenance is 0. Then can the court do that?
No, my lords, here.
So the problem is, so court has given no reason. 2,70,000 if 25%, but if there are 2-3 decisions of this court, that in a conservative estimate, it should be 25%. And that to 2 persons, 2 souls. The lady and the child. Your interstate dispute with the lady does not disentitle her to receive maintenance. Her capability, Rajneesh versus Neha, all these decisions. So you should have distinguished there, not here, that Rajneesh versus Neha is not applicable. Then Reena Kumari, then Mahato versus Mahato, Jain versus Jain, Badhani versus Badhani. You should have distinguished. It is too late in the day to come before the revisional court and say that. In fact, there is no material also. So that is when I am asking you what is the evidence, you are keeping mum.
No,
if you have not adduced the evidence, then there can't be a second innings here.
My lords, the 40,000 that
You
is.
straight away come to the evidence. 40,000 is less than, you have not getting them. 2,80,000 the court has reduced to on its own by 1,70,000 without any reason, believing you.
No, my lord, that is the Rajneesh versus Neha. According to Rajneesh versus Neha document, we have given the annexures for
You are
regard.
supplementing. I'm asking you straight away.
It is
Where
there,
do you
my
find
lords.
the reason that how the court has reduced it to 1,70,000?
Is your lordship may kindly see the salary slip, my lords.
You are not getting, sir. I'm not getting. I gave you example of Bitcoin. Suppose you invest the entire 2,70,000. If it is a taxation, understandable. Taxation, it is understandable. But if it is not taxation, it is your deduction on your own sweet will. Then the court should not.
Lords, the petitioner here gets enhanced salary of 1,69,000, out of which he spends, he lives in Bangalore, my lords. 40,000 goes.
Sir, you are not getting anything. Being briefed by a client and not thinking the law, that's the problem. You produce a salary of 2,70,000, salary slip of 2,70,000. You read the judgment. Then they will understand what you are saying is not correct. Again, para 6, page 6, para 88. You should not miss those words actually.
Lords, it's written to that effect, the respondent has filed his assets and liabilities wherein monthly income is mentioned at 1,69,000, my lords.
We're not reading, sir.
After that, it's written additionally.
That is not there. Full stop is there.
Yes, my lord.
Don't add what's this after that, all these things.
Additionally, the respondent has also filed a list of documents, including a place for the month of April 2025. That is monthly gross income is 2,69,000, my lord.
Yes.
With all the deduction.
Don't explain. I'm not asking you.
And after deduction, he's drawing 1,69,000.
Where? What deduction? What the court should have discussed?
They should have discussed the deductions first.
Yes. Whether the court can discuss. This is the problem when then court has not discussed.
No, my lord.
So that is a ground for, that is to your advantage. Why should you bother if the court has deducted it? So Swami Mata कौन है like? Judgment पड़ा कौन समझे ना? You have to show the evidence. The court does not discuss that.
Asset and liability, my lords, lordship may kindly see Annexure 5, my lords.
I'm not asking assets and liability, Annexure 5. What was the reason for the court to say that the gross income is 269 and the net income is 169?
That is the
court can arrive.
The court arrived from the monthly salary slips, my lords.
Yes, kindly show that. The problem is, yes, Mr. Yes, yes. Kindly look at read the order again. Then you will realize what mistake you are doing. It and yes. It a good order of creation. With most of the এটা যেটা ইয়ে করছেন এটা মিশে না যাতে এটা প্রিন্ট ଅଛି অলরেডি এক্সাম ଆପଣ ଆଉଥରେ ସେଟା ପଢନ୍ତୁ.
Yes, my lords.
Page 88, internal page 6.
Yes, my lords. It is asserted by the petitioners that the respondent is
not reading the relevant. That is how it is missing. You have to be like Arjuna. Only look at that. Additionally, the respondent has also filed documents,
including his payslip for the month of April.
Including his payslip for the month, which goes to trivial that his monthly gross income is 2,69,000.
Yes, my lord.
So how he has then kindly read, and after deduction he is drawing 169, 199. So what are those deductions?
Millards, that are.
So it can't be Millards. It has to be a tax.
It has
to be a loan. It has to be debt servicing. It has to be some statutory liability. Like it can be ESI or any other.
It can be provident fund.
It can be PF also. So that the court's bounden duty is to discuss that.
Yes, my lord. So it is going. The deductions are employees.
Getting sir, where the court has written that?
The court has not. The court has not
so
written.
Why you are taking a half an hour to say that? Why you are taking half an hour to say that? That the court has not given any reason.
So that is what.
So I can't supplement that. I can't go beyond that. I cannot accept that since Mr. So and so is explaining that court did that because you are substituting. You can't substitute the court. I cannot attribute to you. The court should have said income tax this much, ESI this much, PF this much, debt servicing, housing loan this much, car this much. So the court has not done that. So
yes, exactly.
So now the point is that you are not challenging that. So it is a grace for you.
No,
now, even assuming it is 1,80,000, 1,70,000, what is 24% of 1,70,000? It is more than. It is 45 lakhs, 45,000. ଲକ୍ଷେ 80,000 45,000 ହବ.
Yes, ma'am.
କୋର୍ଟ ଆପଣ କେତେ ଟଙ୍କା allow କରୁଛି?
40,000.
40,000. So in any event, you are in a win-win situation.
Because the expenses of the petitioner has not been taken over. There are loans. He's already filling up the insurance for the child and wife, my lords. Everything is taken care of.
You can become bankrupt. You can take loan. Do not pay but is that a consideration in any judgment that if the petitioner has taken loan and in debt servicing the entire amount is paid? That cannot be. That's not the law.
Also,
So now suppose where you have stated in your written statement that you cannot pay, that you have to show me. That I've been asking you. Again, you will take another half an hour.
No, my lords, I've already written that the expenses.
Can be show in your written statement.
Yes, my lords. Yes, my lords. Let me
So,
clarify.
yes. Kindly read 21. Kindly read.
21. Okay, my lords.
Kindly have your attention here.
Yes, my lords.
Just read paragraph 21 of this. Read it aloud.
Having stated the principle, we will have proceeded to record our consequential conclusion, but a significant one. We cannot be oblivious of the assertions made by the appellant. It has been asserted that the respondent has taken voluntary retirement after the judgment dated 17/2/2012 with the purpose of escaping the liability to pay maintenance amount as directed to the petitioner. And the last drawn salary of the respondent taken into account by the learned family judge was rupees 17,564 as per the salary slip of May 2009. And after deduction of AFPP fund and AGI, the salary of the respondent was rupees 12,564. And hence, even on the basis of the last pay, that is 9,830 of the respondent, the total pension will come to rupees 14,611. And if 40% of the commutation is taken into account, then the pension of the respondent amounts to 11,535. And that the respondent, in addition to his pension, had received encashment of commutations to the extent of 40%, that is 3,84,500. And the other retiral dues, that is AFPP, AFGI, gratuity, and leave encashments to the tune of 16,01,455. The aforesaid aspects have gone uncontroverted as the respondent husband has not appeared and contested the matter. Therefore, we are disposed to accept the assertions. This exposition of facts further impels us to set aside the order of the High Court. Consequently, the appeals are allowed. The orders passed by the High Court are set aside, and that of the family court is restored. There shall be no order so as to cost.
Then read 19. Because the first line it says, if you read again the last paragraph, what you read.
Yes, my lords.
The language is, typical of flowery language of Justice, Honorable Justice Deepak Goswami. First line, please mark. We would have first paragraph when it opening line.
Having stated the principle, we would have proceeded to record a consequential conclusion.
Correct. So they are adding this. So this is the mistake you are making in your argument, that before the High Court, what was not there before the trial court, you are arguing. Because it can't be explained, it's a matter of evidence. It is just a matter of chance that in one matter of where the entire value is taken a commutation, this is a loan. Commutation is a loan,
Yes.
he has to repay. Somebody who has retired, he can take a loan of 50 lakhs, prepaid from his pension, that is commutation.
Yes.
I have issued notice in one matter, but I had not seen this judgment. Even the Supreme Court has taken exception to that. Now then read para 19.
From the aforesaid enunciation of law, it is limpid that the obligation of the husband is on a higher pedestal when the question of maintenance of wife and children arises. When the woman
there, so higher pedestal they say. So they are your theory of she having MCA, brilliant academic career. But the problem is that you should have shown her employability and whether she was getting salary, all these things. It's a matter of evidence. Persons with MCA, then or there is a statute that persons having MBA, MCA, law degree are not entitled. Fair enough. But if you are trying to register her claim towards maintenance on the ground of MCA, then either there is a case law or a statute. Both are not there. So now they can kindly recount.
From the aforesaid enunciation of law, it is limpid that the obligation of the husband is on a higher pedestal when the question of maintenance of wife and children arises. When the woman leaves the matrimonial home, the situation is quite different. She is deprived of many a comfort. Sometimes her faith in life reduces. Sometimes she feels that she has lost the tenderest friend. There may be a feeling that her fearless courage has brought her the misfortune.
Not brought.
Brought her to the misfortune. At this stage, the only comfort that the law can impose is that the husband is bound to give monetary comfort. That is the only soothing legal balm, for she cannot be allowed to resign to destiny. Therefore, the lawful imposition for grant of maintenance allowance.
And this still holds. Then next page is very important, because that will lead to where my role as a revisional court, what I can do, because I have to do it for you. That is how you have come to us. Then can you read further?
In the instance case, as is seen, the High Court has reduced the amount of maintenance from 4,000 to 2,000. As is manifest, the High Court has become oblivious of the fact that she has to stay on her own. Needless to say, the order of the learned family judge is not manifestly perverse. There is nothing perceptible which would show that the order is a sanctuary of errors. In fact, when the order is based on proper appreciation of evidence on record, no revisional court should have interfered with the reason on the base that it would have arrived at a different or another conclusion. When substantial justice has been done, there was no reason to interfere. There may be a shelter over her head in her parental house, but other real expenses cannot be ignored. Solely because the husband has retired, there was no justification to reduce the maintenance by 50%. It is not a huge fortune that was showered on the wife that it deserved reduction. It only reflects the non-application of mind, and therefore we are unable to sustain the said order.
So these kind of activities by me will result in a judgment. Comment on me that I do not apply mind. Your problem is that you are going extempore, not referring to evidence. So I have been requesting you, whether you have any additional evidence regarding her employability or her income capacity, and what is the finding, what is your cross-examination on that?
Plus, there is an application we had sent to that effect under order rule 51, Milots, to showing that she had the CV, she was employed, Milots, but that was not taken into account.
That is against you. You have to show that the current income. Section 24, you have to show current income. The person briefing you doesn't understand law.
Let's see, the wife already had fixed deposits.
This can't be a drawing room discussion over a cup of coffee. Your points, we are not playing to a gallery. So even if we are live, it has to be legally nuanced. You have to show legal substance, and your submission doesn't have any.
Let me clarify in just 2 minutes.
No clarification. You bring substance, because I don't want to invite a comment like this, non-application of my mind. You have to show. We should show that a sanctuary of errors. Second thing, order is not based on proper appreciation of evidence on record. These two things we have to show. That is how I have been asking.
So
that evidence you produce that, and so in fact it's a warning, because I can in fact increase it, because 1,70,000 the court has not given any reason. You have marked that.
Yes, Milots.
When you started reading the paragraph. The court, why it reduced because it is based on salary slip. That one line is there, you have read 4 times, 5 times.
Yes,
but court has not gone into details.
Details.
Because a person has received commuted, it's a fact, it's a loan. Is repaying the loan? Because taking a loan is at your choice. And giving maintenance is law choice. So, if you want to compete with law as far as the giving maintenance is concerned, you have no case. You don't stand a chance, in fact, because law has to be enforced. You may not like it. You are spending more money in Bengaluru. You shift to Delhi's more costlier place. Bombay, suppose you shift, the living cost is very high. Those things are not there. But obviously, those are the factors you have to adduce evidence. These are my expenses. And 1,70,000 as far as Orissa High Court is concerned, this 40%, this thing is 25%. So 25% will be more than if you take, and in absence of that deduction of the court, deduction as far as the logic, why it should be 1,70,000? Why not 2,70,000? How it has been reduced? Now you go to your pay slip.
Yes, Milots. Annexure 7, page number 73, my lords.
And there,
Yes, my
and there, but you straight away go to your how it has been reduced. That doesn't show.
My lords, as per the salary slipped, around 19,400.
Straight away go to the entry where it is 2,69,000 has been reduced to 1,69,000. So kindly mark 7.
7, my lords.
You should have been careful in drafting this 7 because it says the standard of life. You are spending 1,40,000 per month.
My lords,
So how much you expect your wife to spend?
my lords, let me clarify.
No, I am not seeking any clarification. The question is pointed.
The
When you are spending 1,40,000, what according to you would be the expenses of your wife?
For every month, the petitioner
Not
is
every month. 1,40,000 is total expenses per year. Your expenses.
for monthly. Sometimes it comes to expenses because either for the GRPS years.
Then you are not looking at it. Look at entry 7. Page 73.
73, my lords. General monthly expenses of the applicant. Rent, household expenses, medical bills, transportation, etc.
Yes, 1,40,000.
In that 1,40,000.
1,40,000 applicant here is?
Applicant, this is not applicant, my lords. It is the respondent here. That is
So that's a typographical error.
the.
So I have understood it correctly. So if you are spending, you require 1,40,000. What would be the requirement of your wife according to you?
Let's see, ideally claimed 2 lakh per maintenance as well.
Sir, I'm not asking, sir. By evading or asking me 3-4 suggestions, I'm not. You are not cross-examining me. Neither I am cross-examining.
My submission is that the
So
expenses.
you must understand the question, then you can answer, and try to concentrate on. If you are saying that 1,40,000, the court has given you 40,000 to the wife. You are saying it is more.
Yes,
so that is one aspect.
That is one
Yes.
aspect.
So now where it has been reduced from 2,69,000 to 69. What are the deductions?
The deduction is below.
Can you show from that? Because you not liking to pay 40,000 is well taken, but that's an illegal ground if I allow that.
It's not attached. Milots, the salary slip has not been attached here, Milots.
Then you have no case. You should not have taken chance for taking 1 hour of the court. That is the fulcrum of your argument. And unfortunately, the court has not gone into that trial court.
No, Milots, it was actually there.
Then read Samima.
Milots?
Samima, I just showed you Supreme Court.
Yes,
what cares at you? What the court should do. Because court is not paying it.
Yes, Milots.
Court may very well say that she is not entitled. Court may give her the salary, the maintenance of, instead of 40,000, it can be 4,000.
Yes, ma'am.
Like that. Court has not given any reason. So that is in your favor also. When this is an order where it is partly in your favor because of the apparent error committed by the court while calculating.
Yes, Milots.
Yes.
Milots, another submission is that the learned trial court has failed to appreciate the evidence that is assets and liabilities filed by the
abstract. Which evidence you adduced? What has been
yes, ma'am, sir.
So that
affidavit, annexure 6, asset 66 page 66, Milots.
Yes.
This is the asset liability of the respondent, Milots. Lordship may come to page.
You read the judgment where it has dealt with, where it has been dealt with by the court. You remember?
Yes,
I remember. You go to the judgment where it has been dealt.
Milots.
You remember where in the judgment the court has analyzed the income of your wife?
No, Milots, this is not.
You look at it. Look at it. That's the problem. You do not remember.
Your Lordships, the trial court has not appreciated the fact that the
To that paragraph, where it has that.
Your Lordships, in the
Don't
entire
start your speech again. I'm really tired of for the last 2 hours. Whenever I'm asking, you point out from the judgment, you are saying something else.
judgment para 5 and 6, my lords. Para 5, it says,
I'm there since long. Since you are searching
heard the counsel from respective sides on verification of the case record.
You
with
straight away go to page 6.
Page
We have
6.
spent a lot of time.
Yes, my lords.
It is asserted by the petitioners that
Petition that the respondent is working as a software engineer in a multinational company and earning 40,000 per annum. To that effect, 40,000 per annum.
40 lakhs.
40 lakh per annum. To that effect, the respondent has filed his assets and liabilities wherein the monthly income is mentioned as 1,69,199. Additionally, the respondent has also filed a list of documents including pay slip for the month of April 2025, which goes to reveal his monthly income is 2,69,000. After deduction is drawing 1,69,000.
So the court has not taken your salary to beyond 1,69,000.
Yes, my lords.
Correct. Read further.
It is contended by the respondent that the petition number 1 is a highly qualified lady for which she can maintain herself. But there is absolutely nothing on record to show that the petition number 1 has any independent source of income.
So this is the finding. So,
Yes.
so what was your evidence to show that she has independent source of income?
Milords, the independent
So
source of
what is
income.
your what is your pleadings first?
Yes,
First is to go to your pleadings.
yes, my lords.
You'll find it. Are you able to get it?
Yes, my lords.
Which page of your brief?
Page number 12, para 30. Para 30 it's written that is humbly submitted to submitted that the learned court below.
Page 12.
Page 12. Page 12 of the petition, my lords.
Your written statement before the trial court. You are a defendant in the trial court, filed a written statement. You have
Yes,
to do
ma'am.
revision here.
Yes, my lords.
Then how you find it in the paragraph of your petition? Anyway, I have to assist you. Your reply is at page 64, annexure 5.
Yes, my lords.
Kindly read where you have said. Kindly read it from the beginning till end. You mark the counters. You can read that.
Yes, my lord.
IA number?
IA number 11 of
That
2025.
makes you confident that you have got the proper page because
Yes, my lords. My
you
lords, yes.
then counter filed by the
Counter filed by the above named OP respondent to the petition under section 24 of the HS Act.
so that's the counter you have.
That's a
filed?
counter, my lords.
Okay. So now you find there where you have suggested that she has independent source of income.
No, my lords, I'm not suggesting that there is an
In
independent
this
source.
case, sir.
My lords, he has a fixed deposit.
Kindly go to the finding of the court. This is not a
No, my lords,
this is not a debate. This is not a debate or a moot court. Please appreciate we are dealing with hard facts and law. Then kindly go to the finding at page 6, internal page 6 of the judgment, and don't get disheartened.
No, my lords, my son.
Because you are trying to. I mean also learn partly that how you to argue a matter
Yes, my lord.
and a revision. Now you read page 88, last line.
Yes, my lords. It is contended by the
There is absolutely. There is absolutely nothing on record to show that petition number 1 has any independent source of income. That being a lawyer also, you squarely and fairly admit.
Yes, my lords.
So then you must understand that court will not go by the very emotional, emotive speech. I cannot. I have a limitation. I very much. I'm impressed with all your speech. But what is the material?
My lords, 1 minute
So,
of indulgence, my lords. I'm not even able to.
Giving you 60 or 70 minutes. If you say 1 minute, it's a disrespect to the court. You should not. So first of all, before the trial court, you look at again. Second chance I'm giving you, where you have stated regarding income of the petitioner. Annexure 5.
Annexure 5.
You shouldn't have stated para 7. Para 7, you have said OP his parents and he spent heavy amounts and got bail orders from the Hon'Ble High Court of Orissa. Why should you say that? That if you commit a crime, suppose you are accused, you get a bail, that the court will take into account. Why should you? These are reckless statements. Suppose this was advised by the person himself, the lawyer should have guided. And the lawyers will not charge fee. Because somebody has committed crime 307, not bailable, he comes to High Court. For that, the court will grant just find out there is nothing.
Yes, my lords.
Para 10 is the only thing you have said.
Yes, my lords.
Can you read para 10? That's the only statement.
Further, the petitioner is a high qualified and passed MCA and was also working with good salary before her marriage. So she can earn for herself apart from the income and bank balance of her parents.
So which law says that if she is employable, she will not get maintenance 40,000, which is less than 25% or around 25%. 1,60,000.
1,60,000.
40 into 4 is 1,60,000. It is 1,60,000. So no case, Mr. Pradhan. You have made a. I mean,
Lordship,
you did not adduce any evidence. Do not cross-examine. Suppose now let us ask you. Have you seen the cross-examination of the lady? Have you read it? Before arguing the matter, have you read it?
Because there was no examination done as of now.
Fair enough.
Because it is on the resolution and mediation is going on currently.
So that was a tricky question. So there is no scope. You admit that there is no scope also. So you could not have cross-examined her regarding that. So you have no case.
Lords, my whole contention was that the fixed deposits of the wife that's not been considered.
Is not a speech. It's a matter of writing in your written statement.
Because that I have written that
kindly go to the page 64-65. Appreciation by the court. Because now I will record whatever you have said. I will record. Of course, it is recorded in YouTube. But take your submission seriously.
Yes.
So why you have stated in page 64-65 and what has been done by the court. Court has taken note of 10.
No, sir, mentioned in the petition itself, my lords.
It's not petition.
No, that is the response to the 11. Written statement to section.
You have to take care of your pleadings because court personally knowing many things is not out of question. Court's impression. My impression about an NCA lady or a person working. Suppose I know that he's getting, the employer is known to me, he's actually getting 40 lakhs per annum. So it comes to 3.5 lakhs per month. Can I? So that is how you test a logic. I know the company, I know the owner and so many things. I know that the person is getting 40 lakhs. Can I? I cannot. I have to go by the pleadings. And if something is in your favor, the court has reduced into 2,69,000 to 1,69,000. I can, as a supervisor jury, I have 227. I can interfere. The court has not given any reason for reducing it. But since he has not come, it is you who have come. It is your petition. There is no case, Mr. No case. And regarding preparing when you were arguing constitutional law, like you argued that law commission interpretation, then you should be careful. Because we are watched. Somebody sitting somewhere will say that what is this submission? That the lawyer is arguing that the law commission report has to be given effect to by the court. So that is how the last part I showed you that they suggest an amendment. The amendment is to be made by the legislature. Till the amendment is made.
That was my argument.
No, you should not. You should not.
We'll consider lots.
You must keep a tab on your enthusiasm to argue anything and everything. And if you have an argument, yes, law commission needs to be, then complete it. Go to the hilt. Let the court consider it. You have a citation. Suppose, in fact, I could not understand also. Whatever I am understanding, I am telling you. I am just sharing with you. That perhaps you are arguing that the court could not have gone to the issue of the child's maintenance. That is your submission.
This
Anyway, that's
that and the second argument was that she has already filed.
and always in case of revision, first appeal, second. The beauty of trial court is that it is pleadings and all evidence. The classic analysis of law. I mean, we sitting in, I had very little practice. You can say nil practice in trial. I always confined to the appellate side. But there are courts like Delhi, Calcutta, they have their original side also.
Yes, ma'am.
So when the lawyers get opportunity, even if in appellate court, they appear in both sides. So unless you concentrate on the evidence and the pleadings, 99% you will falter in your approach. Because after arguing in the court, you cannot turn the page and discover what is there in the pleading. Because you are already committed. You have made your point. So now your point will be tested by the court looking at the pleadings or the evidence. And here is a case, it is in the interim nature.
Yes, ma'am.
It is in the interim nature. It is very difficult. As you said that there is no strict, you can cross-examine and examine, no difficulty. Court may, if you suppose you file a petition for calling of the witness and examining her, or she may call you, court may allow, court has power. Nobody can take exception to that. That is again, it's not a correct interpretation suggested by your briefing counsel, maybe your senior. That's not a correct position. Because that provision is there in the procedure itself, evidence. The court can ask questions also. No case. And rather, you should be happy that court has been lenient in reducing your.
Milots, there's another ground, Milots.
Yes, please.
The second ground is that there was an IEA filed under IEA 48 and 49, under 24 and 25 Milots. Both were withdrawn. But no relief was, no sort of.
25 who filed in which petition?
In the same, arising out of the same MAT case, Milots. From the same MAT case, there were two IEAs under section 24 and 25 filed. They were withdrawn. With no liberty taken from the court to file it again. Judicata, Milots.
Have you examined this?
Milots?
Have you examined that 24, the subsequent filing of 24 is a res judicata?
Milots, this one.
I would always request you be serious in your submission. 13, suppose 13 is withdrawn, then is it res judicata?
No, Milots.
9?
No, Milots.
Then 24 arising out of 9, how it will be res judicata?
Milots, they have filed the section 9 petition with section 24.
You have to be very careful. If you read and prepare, it will help you. Don't make these kind of submissions. I mean, just simply you are plucking from the air. If 13 and 9 are not res judicata for a subsequent petition, the reason is apparent. Today the person's pulling on very well, but tomorrow fall apart. Today they reconcile and they withdraw the 13. 13 can be filed every time. Every time there is a dissension. 9 can be filed every time when there is a desertion.
The Lordship may kindly see page number 56.
No, sir, first of all, you are not prepared with your facts and written statement and evidence. You have taken me to Law Commission report. I have asked you that if Law Commission report is empowered to legislate or suggest amendment, or it is a legislation itself. That was my query to you. There is no concept there. Then you have taken me to the pay slip, that paragraph, that last line in page 6. There is absolutely, the court is correct in its finding. Then though you might not have examined Samima, so the scope of revisional court examining a matter is very articulately said in Samima. And that is still the law. It is old principle. The duty of a revisional court or scope of revision of an order is old principle. But that Samima has again said. So beyond that, if I start looking here and there pages, it is already we have spent substantial time. There's no case. And one more thing, Mr. Pradhan, the case is as good as it is presented to you. When you are receiving a brief, the material with you is the only case. Initially, as a student of law, Still, I continue to be a student of law. I heard a very famous lawyer, very famous author also. He always used to return the brief. Somebody comes to the law, him and he will accept it, examine, and he will say that no case. My personal understanding is that let the court decide. Why I as a lawyer will decide. But he used to always do. A very senior, very reputed person. Even to that extent, a lawyer can go. My point too is that you can tell your client on his face that, sir, you did never produced any evidence. Don't expect that I will make a speech, impressive speech. Here we are not playing to public gallery. We are within the perimeters of 24, 25, 39. Justice versus Neha, Samima Faruqi, all those decisions. And 24 is very clear, it is an interim management. And don't argue res judicata when it is not applicable, because that shows that you have not, perhaps you have not read that aspect or considered that aspect, whether a 13 petition or 9 application is res judicata for the subsequent. Same ground also. Because as I told, desertion. Today you are staying together. Somebody is not about you. X and Y are staying together. Y leaves. X files section 9. Tomorrow they come back. Stay together. X withdraws it.
Since the petition MAT case was filed under section 9, read with section 24, and then subsequently after 4 years another petition under 24 was filed.
Every time there is the reason is very simple. This is nothing too difficult.
Since my submission was that since the MAT case was...
It is not a continuing cause of action, but it is a fresh cause of action. Suppose you are the 1,40,000 you are spending for you are spending for your wife. This case, this will be a classic example. Can she file a 24 application? You show the court that I am filing 1,40,000 for my wife. Can she maintain a section 24 application? She cannot. After spending 1,40,000 for 6 months, 7th month you do not spend a pie. Can you take a plea since I have been spending 1,40,000 for my wife for last 6 months? I will not maintain her. Section 24 will be maintainable. 125 will be maintainable. Financial assistance will be maintainable in DV Act. So this is not a recurring cause.
That is one.
Or the problem is that it's not res judicata because it's a fresh cause of action.
No, just another ground that I was trying to impress upon your lordship is that when the MAT case was filed under section 9, in the very first page itself is a section 9 read with section 24 and 25. And then after 4 months...
Sir, everyone is not reading law. You expect me that, or shall I comment that who has filed a lawyer, he doesn't understand law? While section 25 will be written in a section 9 petition. Please appreciate, sir. Sir, one thing, Mr. Pradhan, at least I try to be more measured in my comments, and more so when I'm in public view. Just imagine how much he would have secured in why there is so large number of failures. Family law 1 and 2. Why so many students fail? 60% failure, 50% failure. You will be surprised that I know lawyers who have ultimately become lawyers, failed in family law paper, passed second, then here. So you don't have power. You should have power.
No, I have power, my lord, sir.
Okay, they have not mentioned. Mr. Rahul Pradhan for the petitioner. You take your seat. I have to take some time to dictate.
Much.
The petitioner husband in the marriage is before this court. Challenging the order passed by the learned judge, family court. In IN number 11 of 2025. Family court जो लिख रहे हैं the challenging the order they take, so the data छाड़ दिए पर लिखिए अलॉट किया कोड़े पर 18/11/2025 passed by the learned not family court learned civil judge senior division into bracket Bhanjanagar Ganja. Sentence complete. Stop. The IA 11 of 2025 arises out of MAT case number 62 of 2021. filed and pending before the said court. The MAT case 62 of 2021 was filed under section 9 of the. You are right, he has written section 9, 24 and 25. He is correct. Everything is written.
Yes.
Like 226 and 227 of Constitution. 227, 220 purpose is different. 227 is
supervisory.
He should not have written 25.
Yes, my lords.
Anyway, take your seat. Call next. 9, by the opposite party wife in the marriage, seeking restitution of conjugal rights. Hello. The IO was filed under section 24 of the Hindu Marriage Act, claiming maintenance pendente light at the rate of rupees 2 lakhs per month and a consolidated litigation expenses of 30,000. So, however, while allowing the application, say, IA is the application, correct. When allowing the application, the court has directed payment of sum of rupees 40,000 per month to the wife in the marriage and also who is also the mother of the minor child. The maintenance granted is the consolidated sum for both the mother and child. The learned counsel for the petitioner was heard extensively, and he raised the following contentions challenging the order. Law Commission report are there. Referring to the Law Commission report.
Second page.
Report of the Law Commission of India, April, 1984. The report of Law Commission of. Sorry. तो रिपोर्ट अगला 98th कर दियो 98 referring to the 98th report of Law Commission of India on sections 24 to 26 of Hindu Marriage Act 1955 colon orders for interim maintenance and orders for the maintenance of children in matrimonial proceedings. It is suggested by the learned counsel for the petitioner that the courts adopted. You are saying the wife should have. The wife should have approached the court separately, or you want the court should have behaved, passed a different order. What is your suggestion on Law Commission? Because
Law Commission, if the wife was filing a petition, she should have filed for herself only as per section. And if the child wanted under 26.
Correct.
Much obliged.
It is submitted by the learned counsel for the petitioner. Courts adopted by the opposite party wife in claiming maintenance pendente light should have been application under Section 24 of the Hindu Marriage Act for her and application under Section 26 of the Hindu Marriage Act for the child, and not a consolidated application, public single application. In response to the said submission, it would be suffice to say that Chapter 7 of the recommendations itself, chapter 7, comma, recommendations of the report itself clarifies the situation that the Commission has suggested amendment of the Act and nothing beyond that. After the suggestions, the Act has not been amended. It remains as it is. This court or the learned trial court that has decided the matter could not have relied on the Law Commission report so as to accept the interpretation that is tendered by the learned counsel. Regarding the quantum of maintenance granted, that is 40,000, instead of rupees 2 lakhs as demanded, it is submitted by the learned counsel for the petitioner that determination of 40,000, rupees 40,000 as maintenance is incorrect, is result of incorrect appreciation of material on record by the learned trial court. This should have been your summation actually, because you have to sharpen your straight away you hit it. Though I am framing myself and rejecting it, but you have to, don't say so many things. Straight away go to the material and say that this is the conclusion, they are opposed to each other. That's it. Like you have said regarding Law Commission. Law Commission, suppose I accept your contention that since the Law Commission has said there should be a 24-26 separate application. So you have made that point very sharp. Though I could not initially what you were intending, and it took time because it's an unusual submission.
Yes.
One in 100 or one in 1,000 cases, you hear submissions like this.
No,
Take your seat.
not
It's contrary to trial court. In response to the said submission, the learned counsel was on being asked, the learned counsel takes this court through the paragraphs 5 of the impugned order, where the learned trial court has discussed para 2, para 4 and 5, ठीक है sir. Which are reproduced here. Going through paragraph 5 of the judgment, apparently the learned court has accepted the monthly gross income to be rupees 2,69,908 and has also accepted the deduction to arrive at a conclusion that the petitioner is receiving rupees 1,69,199. Regarding the deductions, the court has absolutely given no reason apart from referring to the pay slip. On being asked, the learned counsel, on being asked to refer to the pay slip that was on record before the learned trial court, the learned counsel for the petitioner submits that that has not been annexed to the petition. Stop. At this stage, the legality or otherwise of the court, the legality or otherwise of the approach of the court to reduce the salary by from 2,69,908 to rupees 1,69,199 need not be gone into. The learned counsel was further asked that to support the submission regarding income of the opposite party wife, what was the material adduced before the learned trial court? The learned counsel refers to the within single court counter filed by the petitioner who was the respondent before the learned trial court. Having gone through the said the reply, having gone through the said reply filed by the opposite party, present petitioner, paragraph 10 is the only paragraph which refers to the income of the opposite party wife. কোনটা লিখবে নি যে রিপ্লাইটা সেটা 12/8/2025 ডেট করতে 12/8/2025 ବିପିନ ବେହେରାରେ ଅଛି RPFM 13/2025 ସମୀମା ଫାରୁକ ନା para 15. Now, in view of the above discussions and the submissions made on behalf of the petitioner, the question that falls for adjudication for entertaining the application is that whether the order passed by the learned family judge is manifestly perverse. Second point, whether there is anything perceptible which would show that order is a sanctuary of errors. Third point, whether the order is based on proper appreciation of evidence on record. Fourth point, even if, no, sorry, if all the above 3 points are answered in favor of the petitioner who is challenging, if the revisional court can interfere, because the revisional court would arrive at a different or another conclusion. The next point, whether substantial justice has been done by the learned court which has passed the order. Applying these principles as enunciated by the Honorable Supreme Court in Samima Faruqi Supra, in considered view of this court, it has to be held that the judgment is based on the correct appreciation of material on record, there is no perceptible error in the judgment. To arrive at the conclusion, as has been done by the learned trial court, it has gone through and appreciated the pleadings in their proper perspective. It has taken note of the affidavits filed by both the parties, indicating assets and liabilities. Further, voluntary rejection was argued by the petitioner as a defense for not paying any maintenance. The court has made the said issue open during pendency of the CP. Accordingly, the petition being devoid of any merit is dismissed. Copy of this order shall be forwarded to the learned judge so and so in so and so. Yes, you keep it up, Mr. Well done, and you become more focused. And as a junior, I never suggested any to my seniors.
In this read petition, my lord, the petitioner has challenged the impugned order passed by the learned judge of Family Court Rourkela, rejecting the application of the petitioner filed under section 151 of CPC in CP number 18/2020. In the case in question, my lord, the petitioner has challenged the petitioner has narrated the impediment which prevented him not to attend the court. Although he has secured Order 9 Rule 13 in CP number 9/2017, the learned judge Family Court set aside the impugned order passed ex parte on 11/9/17 and directing to deposit cost of ₹5,000 and allowed him to file the WS even after relaxing the limitation period. So, without properly appreciating the application under section 151 of CPC, the learned judge has rejected the CMA number 18/2020 on 23/4 on.
Sir, after your sir, can you please answer a few questions for me to understand?
Yes, my lord.
There is you were set ex parte.
Yes, my lord.
Or your opponent was set ex parte.
No, I was set ex parte.
So what is the nature of proceeding?
The proceeding of the order section 18 and 20 of the petitioner wife and her daughter, minor daughter, filed section after 18 and 20 application in CP number 235 by
Correct,
2013.
sir. Sir, under which provision? Section 18 and Hindu Adoption Maintenance Act. Seeking maintenance?
Section 18 and 20 of Hindu Adoption and Maintenance.
Seeking maintenance. So that was allowed ex parte or you were set ex parte?
I was set ex parte because you not attending the court.
Then you file order 9 rule 13.
File kara hala, my lord.
Yes. After you file order 9 rule 13, there is a conditional order. You pay 5,000 and it will be restored. You will be allowed to file WS.
Thereafter, my lord, the
Then you have to listen to me. Then you can understand. So did you comply the condition in order 9 rule 13 order?
It could not be complied because my lord, all the bar association of Raurkela bar, he made seized work, and therefore he could not come and deposit the cost in time, scheduled time. And thereafter,
Sir, when was the direction to pay cost?
it was a pay cost to director. What? 28/8/2018. 28/8/2018. Thereafter, the court was
so thereafter kebe hela strike kebe hela?
Strike hela September 2018. Strike kale 2018. September 2018, and it continued for a long period. Siege work kala. Thereafter, my lord, the younger brother and mother of the petitioner fell seriously ill and succumbed to the disease also.
So after the recall of the siege work that siege work call.
Yes, my lord.
So then kindly mark the judgment page 11.
Yes, my lord.
Running page 11.
Yes, my lord. Yes, my lord.
Kindly place there. It is further stated.
I have no judgment, my lord.
Yes. Running page 11 of your brief.
My lord, impugned order.
Yes.
Impugned order. Yes, my lord. At page 11. It is further stated. It is further stated by the petitioner that thereafter the local bar members observed the siege work from September 2018 till more than 1 year.
So September 2019, kindly mark the date. September 2019.
Yes, my lord.
Yes.
Till more than 1 year. During that period, he had been to Raurkela court for many times to pay the cost for compliance of the order of the court, but could not be able to make. Thereafter, the petitioner could not receive any information from his advocate when strike was called off. It is specifically stated by him that on 4/2/2020 he visited the court and inquired about the status of the CMA number 9/2017 and came to know that the CMA number 9 was disposed of on the 27/11/2019, declaring the order passed on 28/18 in CMA number 9 by.
So the problem is that have you stated this? You are contradicting yourself.
My lord?
The petitioner is contradicting himself because he says that after there is a direction to pay 5,000.
Yes, my lord.
I went to Raurkela court several times.
Yes, my lord.
Then in the next line he says He inquired about CMA number 9 of 2017 and came to know on 4/2/2020.
Yes, my lord.
Upon Judah plea level, you take impossible plea, so the court cannot do anything.
For that reason, 150.
ଆପଣଙ୍କର 5,000 ଦେବେ ବୋଲି କୋଉ ଦିନ ଅର୍ଡର ହେଲା?
Yes, my lord. It was
For that reason,
it was passed on 20/8/2018.
ଆପଣ ତାପରେ ସବୁଦିନ ଷ୍ଟ୍ରାଇକ୍ ହେଲା କହୁଛନ୍ତି କୋର୍ଟରେ କହୁଛନ୍ତି ମୁଁ ସବୁଦିନ କୋର୍ଟ ବୋଲି କୋର୍ଟରେ ଷ୍ଟ୍ରାଇକ୍ ହେଇଥିଲା ତାପରେ କହୁଛନ୍ତି ଯେ ମୁଁ 4/2/20 ଜାଣିଲି ଯେ ସେ କେସ୍ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯାଇଛି ବୋଲି ସେ କେସ୍ ଡିସ୍ପୋଜ ଅଫ୍ ରେଷ୍ଟୋର ହେବା ପାଇଁ ଅର୍ଡର ହେଇଥିଲା।
Yes, my lord. Therefore, he filed it.
ହଁ ତେଣୁ ଆପଣ କଣ ଆପଣ ଚାହୁଁଛନ୍ତି କଣ କହିବା ପାଇଁ ଏଗୁଡା କଣ ତାର ତ କିଛି ବୁଝିବି ହଉନି ଆପଣ ତ ବୁଝିପାରୁନାହାନ୍ତି ସେଥିପାଇଁ କିଛି କହିପାରୁନାହାନ୍ତି ମୁଁ ତ ବୁଝିପାରୁନି ଯଦି ସିଏମଏ ରେ 5,000 ଟଙ୍କା କଷ୍ଟ ହେଲା ଆପଣ ସବୁଦିନ କୋର୍ଟକୁ ଗଲେ ଏବଂ କହୁଛନ୍ତି ଯେ ଯେହେତୁ ଷ୍ଟ୍ରାଇକ୍ ହେଲା ସେଟା ଦେଇହେବ କି ନାହିଁ ମୁଁ ବି କହିପାରିବିନି କାହିଁକିନା ଆଇ ଥିଙ୍କ ଷ୍ଟ୍ରାଇକ୍ ହେଲେ ବି ଆପଣ ଡିପୋଜିଟ୍ କରିପାରିବେ।
Yes, my lord.
ଜଜ୍ ଷ୍ଟ୍ରାଇକ୍ କରିଥିଲେ କି? ତ ତାପରେ ଆପଣ ଦେଖନ୍ତୁ ତାପରେ ଫର୍ଦର ପଢନ୍ତୁ ଆପଣ ତେଣୁ ସେ ପଏଣ୍ଟ ଆପଣ ସେଇଥିପାଇଁ ପଳେଇଲା ତାପରେ ଦେଖନ୍ତୁ
CM number 9/2 disposed upon 27/11/2019 declaring the order passed on 28/18 in CMA number they became infructuous due to his non-attendance and the judgment and the decree passed in CP number 235 came into force. It is further contended by him that his brother, namely so and so, his mother also fell disease and they also succumbed to the disease on such and such date, my lord, which prevented him from not attending the court.
ଆପଣ ଗୋଟେ ଡେଟ୍ ଗୁଡାକ ମାର୍କ କରନ୍ତୁ ସେଥିରେ ଆପଣ 25/3/19 30/3/19 7/4/19 ଆପଣ ତା ପୂର୍ବ ପାରାଗ୍ରାଫରେ କହିଲେ ଯେ ଆପଣ ସେପ୍ଟେମ୍ବର 19 ଯାଏଁ ଯାଉଥିଲେ କୋର୍ଟ ଯାଉଥିଲେ
ଆଜ୍ଞା
ଆପଣ ତ କୋର୍ଟ ଯାଉଥିଲେ ତା ଦେହରେ ଆକୁ କଣ ଫେର ଲେଖିଲେ?
His brother and mother fell seriously ill while attending them and they also succumbed.
ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଯେ ସେ ଯୋଉ ଷ୍ଟ୍ରାଇକ୍ ହେଇଥିଲା ସେଟା ଆପଣଙ୍କର ଆପଣ ଜାଣିଲେ ନା ପଇସା ଦେବା ପାଇଁ ଯାଉଥିଲେ ଦେଇପାରିଲେନି ଆପଣ କହୁଛନ୍ତି ଆପଣ ସେଇଠି ଲେଖିଲେନି ଯେ ଆପଣ ଆଉ ଥରେ ପଢିଲେ ବୁଝିପାରିବେ। From September 18 till more than 1 year during period he had been to Rourkela for many times to pay the cost. ଆପଣ ନିଜେ କହୁଛନ୍ତି ଯେ ସେପ୍ଟେମ୍ବର 19 ଆପଣ ରାଉରକେଲା ଯାଉଥିଲେ କଷ୍ଟ ଦେବା ପାଇଁ ଆଉ ଦେହ ଖରାପ କଥା କଣ ଲେଖୁଛନ୍ତି ତାର ତ ତା ପୂର୍ବ କଥା ସେଇଟା
ତାପରେ ତା ଦେହ ଖରାପ ହେଲା ନା ମ୍ୟାଡମ
ତା ପୂର୍ବରୁ ହେଇଗଲା ଆଜ୍ଞା ସେପ୍ଟେମ୍ବର 19 ପୂର୍ବରୁ ଆସିବ ଆପଣଙ୍କର ଇଏ ମାର୍ଚ୍ଚ 19 ଆଉ ଏପ୍ରିଲ 19 ଆଉ ମୁଁ କେମିତି ଏବେ କହିବି ଯେ ଆଜ୍ଞା ସେପ୍ଟେମ୍ବର ପରେ ଆସିବ ଏପ୍ରିଲ ଆଉ ମାର୍ଚ୍ଚ ଏପ୍ରିଲ କେମିତି ସେପ୍ଟେମ୍ବର ପଡେ ମୋର ବି ଉଲ୍ଟା ହେଇଗଲା ଆଗ ମାର୍ଚ୍ଚ ଆସିବ ତାପରେ ଏପ୍ରିଲ ଆସିବ ତାପରେ ସେପ୍ଟେମ୍ବର ଆସିବ ଆଫ୍ଟର ବର୍ଷେ ଯାଏ ରାଉରକେଲା ଯାଉଥିଲେ ପଇସା ଦେଇପାରିଲେନି ଚାଲିଥିଲା ଷ୍ଟ୍ରାଇକ୍ ତାପରେ ହଠାତ୍ କହିଲେନି ଯେ ମୋର ସେପ୍ଟେମ୍ବରରେ ଯଦି ବି ଲେଟେଷ୍ଟ ଆସିବ ଯେ ଆପଣ ଯୋଉଟା ଭୁଲ କହୁନଥିବେ ମାନେ ସେ ପିଟିସନର ଭୁଲ କହୁନଥିବେ ମାର୍ଚ୍ଚ 19 ସେପ୍ଟେମ୍ବର 19 ଆପଣଙ୍କର ଦେହ ଖରାପ ଥିଲା କିନ୍ତୁ ଆପଣ ତ ଯାଉଥିଲେ ନା କୋର୍ଟ ନିଜେ କହୁଛନ୍ତି ଯାଏ ଆପଣ ଯାଉଥିଲେ ତାପରେ ପଢନ୍ତୁ page 13 ରେ ପଢନ୍ତୁ
permitted to read out this judgment.
ହଁ ପଢନ୍ତୁ नो डिफिकल्टी ସାରଙ୍କର ଯଦି କିଛି ଆପଣ ପଢିପାରିବେ ପାରା 6 ପଢନ୍ତୁ ଫେରେ
ମିଲାଡ
ସେ ଯୋଉଟା ପଢୁଥିଲେ ତାପରେ ପାରା 5 ଯାଏ ପଢିଛନ୍ତି
Millard, it is evident from the record that after judgment and decree passed
ଟିକେ ଆସ୍ତେ ପଢନ୍ତୁ ସେ ଆପଣ ମାନେ ଜୋର ହେଇଯାଉଛି ମାନେ ଆପଣଙ୍କ ଭଏସ ଟା ଟିକେ କମେଇ ଦିଅନ୍ତୁ
Millard, it is evident from the record that after judgment and decree passed ex parte in civil proceeding number 235 of 2000, the petitioner
who was the respondent, preferred CMA 9 of 2017 by filing a
ଶୁଣନ୍ତୁ ସେଇ ପାର୍ଟରେ ଆପଣ ଯୋଉ ଡେଟ୍ ଟା କିଛି ଦେଲେନି, କୋଉ ଦିନ ସେଟା ଅର୍ଡର ହେଲା 5,000 ଟଙ୍କା ଅର୍ଡରଟା କୋଉଠି ହେଲା, ଅର୍ଡରଟା କୋଉ ଦିନ ଡେଟ୍ କୋଉ ଡେଟ୍ ରେ ହେଲା?
last part of the said paragraph, it was written that this court allowed his prayer on contest subject to payment of cost of rupees 5,000 to his wife.
କେତେ ଥର ପଚାରିବି, ଡେଟ୍ କୋଉ ଦିନ 5,000 ଟଙ୍କା ଅର୍ଡର ହେଲା?
28/8/2018
ଠିକ ଅଛି, ତାହେଲେ ସେ ଡେଟ୍ ସେୟା ଅଛି, ତ ପାରା 6 କିଛି ନାହିଁ, ଆପଣ ପାରା 6 you have already submitted.
Milord.
ତାପରେ 7 ଟା ପଢନ୍ତୁ।
Milord. On further perusal of the CMA 9 of 2017, it is further noticed that after passing of order on dated 28/8/2019, the present petitioner remained absent till 27/11/2019. It is also evident from the record that his wife, opposite party number 1 in this case, was coming to the court regularly. Hence, the plea taken by the
now କେମିତି plea ନେବ ଆପଣ? ଆପଣଙ୍କର lawyers are not allowed to participate in matrimonial proceeding. They appear as amicus curiae. You have obtained an order in your favor. You do not honor that order. What the court will do now? How the court will say that there was strike? Court is a factual finding.
Milord.
When the order sheet has been maintained, wife versus husband.
Milord.
The wife has attended all the courts, order sheet is there. Now the court will record that since the husband was not appearing due to strike, how it can be possible? The court will not make this mistake. I mean, court has then the trial court will face the wrath of the High Court. Suppose the wife now files a 227 application that though I appeared, the court has observed that there was strike. You must understand what you are submitting. When you are taking pleas maybe, I don't know, that pleas are taken to be explained something, but it can't be impossible and not plausible. The strike is now become an impossible plea in view of Part 7.
Milord, for that reason, section 151 of civil procedure.
151 CPC cannot override a situation where the court is functioning and the court will record that since you file an application, court is the lawyers are not a strike. Please appreciate this. How the court will record that? How a judicial officer will do this? He cannot. And your problem is that even if you have yourself said that despite the illness of in your family, some members, that is true, but you are appearing in court. And never take a plea of strike by lawyers. That is declared illegal by the Supreme Court. So now suppose let us assume looking at the other side. This is now restored. What would happen? What is the award made?
You will pay the cost and file WS, my lord.
WSA, what is the award made ultimately? Or WSA, the court will pass the same award again. Is there any merit in the WS? That is, I am asking you.
My lord, that would be merit in
the petition.
No, my lord. By the time he filed this
1820. So 1820. So look at now 18 and 20, not 125. 18 and 20. I stand corrected.
18 and 20.
No case, Mr. Patra, nothing. This is impossible. This is an impossible situation now. If I cannot accept that plea also.
My lord, it is pertinent.
Because if I allow your petition, then I have to accept the plea that the lawyers went on strike, and the order sheet shows that the wife has appeared on every day.
My lord, one thing it is pertinent to mention that by the time she filed the maintenance application under section 18 and 20, she has already got employment, and that document is procured later.
So whatever, sir, for recalling that order or you from that ground, it cannot be done. For modification, whatever provision is there, you file. If there is a provision under the statute that if somebody getting employment is not entitled, then that petition is separate. But now you do not pay 5,000, you get an order in your favor, court is lenient, grants you, and it is a small amount. Order 9 Rule 13 is allowed, and the petition is pending since 2017. 18.
No, 2000.
2013.
Yes, my lord.
One is 13, one is 19. So it's a now almost 13 years, 19 now it is 7 years.
Decree passed on 11/9/17, my lord.
File kebe hela sir, file kebe hichi.
In 2013, my lord.
13 kouchanti, mu bhi 13 kouchi, so we both converse on that. There is nothing in the case.
My lord,
I cannot.
it is pertinent to mention that by the time she filed the claim maintenance application, she has already got employment and that document is.
Sir, very good point, but that doesn't mean that I'll accept the contention that the lawyers were on strike and you did not pay 5,000. My difficulty is something different. My difficulty is that I have to accept your contention that lawyers were on strike and the 5,000 was not deposited.
Yes,
because court allowed your prayer. Is it that the court did not allow your prayer for Order 9 Rule 13? Order 9 Rule 13 has been allowed.
Yes, my lord.
So you then prefer to chop up the branch where you were sitting. And you chop the branch into so many pieces for about 3-4 years.
Yes, my lord.
So what can be done? So in case of maintenance applications, there is always a clause for 18 scope, I do not know. 125 it is there, 25 it is there, 24 also there. So you can always file a petition that amount should be stopped because of the changed circumstances. But regarding 18, I cannot say. But anyway, I can't accept this plea that because you have succeeded and you have chosen to act against yourself.
My lord, that is
Somebody in the maintenance application, somebody is getting a chance. And what is the direction for payment of maintenance?
to the wife 7,000 and to the minor girl, the daughter 5,000, my lord.
So
7,000.
Challenging a 12,000 direction, not paying 5,000.
Yes, my lord.
And saying that taking a plea that's on strike. Then now in the order sheet, wife has appeared on every day. So what can be done? Nothing can be done.
My lord, it is pertinent to submit that by she filed the claim application.
I cannot go beyond the pleadings. I spent almost 2 hours in a matter for nothing. There is nothing on pleadings. It can't be reviewed here. I will consider this as per this is again a writ petition 227 power. I have to go through the pleadings and evidence before the trial court. I cannot simply throw it out because I am a supervisory court. I have not looked at what is the plea, what is the direction. Nothing can be done.
My lord, what happened is that by the time she filed the CP number 235/2013,
that point is well taken, sir.
You has got employment.
Sir, on the same date, you should have filed a written statement. You should have filed a written statement.
He could not file that for his.
Her employment did not prevent you from filing a written statement. What is the point if I note that she has got employment and she is not entitled? Because I am not the trial court. I cannot do that.
affidavit.
There are persons who do not consult, they do not heed to the lawyer's advice. I have seen that, Mr. Patra. This could be the case. He is not listening to the lawyer. He does not care for the court's order. And he is also not caring about himself. He has a court order in his favor, very lenient order. And 12,000 is the awarded amount. Directs you to pay only 5,000 to restore the petition, and he will file WS. Still then you are not complying the order. What can be done? And what reasons I will ascribe, Mr. Patra, with your vast experience, what reasons I will ascribe that the court is not correct? Can the court accept that there is a strike and the lawyers are not appearing? Cannot be. No case, no case. Petitioner is before this court. Petitioner husband is before this court challenging the order dated 29/4/2023. Passed in CMA number 18 of 2020. The CMA number 18 of 2020 has been was filed under section 1 of the Civil Procedure Code for setting aside the order passed ex parte against the petitioner dated 27/11/2019 in CMA number 09 of 2017. Let's stop quoting. The CMA number 2017 arises out of CP number 235 of 2013. Stop. The civil proceeding number, the CP number 235 of 2013 was filed by the opposite party wife in the marriage. And the child, minor child, then aged about 8 years. Minor girl child, then aged about 8 years. Stop. Stop notary karantu under the provisions of under section 18 and 20 of the Hindu Minority and Guardianship Act, 1956.
I don't know, Hindu Adoption and Maintenance Act.
Hindu Adoption.
Yes, thank you. I stand corrected. Hindu Adoption and Maintenance Act, 1956.
No, Hindu Adoption.
Hindu Adoption and Maintenance Act, my lord.
ମୁଁ ବି ତ ସେୟା କହୁଛି ମାଇକ୍ରୋ ଉପରେ କାଗଜ ପଡିଯାଇଛି ବୋଧେ ହିନ୍ଦୁ ଆଡପସନ ମେଣ୍ଟେନାନ୍ସ 1956 ନା ଆପଣ କଣ ଶୁଣୁଛି ଠିକ ଶୁଣୁଛି ଠିକ ଅଛି ଷ୍ଟେନୋକୁ ବି ଠିକ ଶୁଣୁଛି ହିନ୍ଦୁ ଆଡପସନ ଆଣ୍ଡ ମେଣ୍ଟେନାନ୍ସ ଆକ୍ଟ 1956 ହେଲା. The CP number 235 of 2013 was disposed of by order dated 11/9/2017 ex parte due to non-appearance of the petitioner, who was the respondent in the said CP. For setting aside the ex parte order, the present petitioner filed CMA number 09 of 2017 under Order 9 Rule 13 of CPC. Stop. The CMA number 09 of 2017 was allowed in favor of the petitioner by order dated. The order ta authore kuhuntu
28/8/2018, my lord.
28/8/2018. The order was stopped. The order was conditional.
28/8/2019.
28/8/2019, my lord. ସେ କଣ ଏଟା ଦେଖିଛୁ?
ଆପଣଙ୍କର ବ୍ରିଫିଂ କାଉନସିଲ ଠିକ କହୁନାହାନ୍ତି। ଯଦି 28/8/2019 ହବ, ସେପ୍ଟେମ୍ବରରେ 5,000 ଟଙ୍କା ନେଇ କାହିଁ ଯାଉଥିଲେ କୋର୍ଟକୁ? 28/8/2018 ହେଲେ ସେପ୍ଟେମ୍ବର 18 ମସିହାରେ 5,000 ଟଙ୍କା ନେଇ କୋର୍ଟକୁ ଯିବେ ଏବଂ ବାରମ୍ବାର ଯିବେ, କହିବେ ଯେ କୋର୍ଟରେ ଆପଣ ଷ୍ଟେଟମେଣ୍ଟ ବି ଦେଖିବେ ନା। ସୋ ଦ୍ୟାଟ ଇଜ ହାଉ ୟୁ କୋରିଲେଟ ଦ ଫ୍ୟାକ୍ଟସ। 28/8/18 ହିଁ ହବ। ଆପଣଙ୍କୁ ପଚାରି ପଚାରି ମୁଁ ବି ତ ନିଜେ ମାନେ ଲାଷ୍ଟକୁ ମୋର ବି ଗଲାଣି। 28/8/18 କି ସେ ଅର୍ଡରଟା ବି କୋଉଠି ଆପଣ ଆନେକ୍ସ କରିନାହାନ୍ତି?
Annexed 2 point ହେଇଛି। କେବେ ତ 28/8/2019
ହେଇଥିବ ନହେଲେ ଆଜ୍ଞା ସେପ୍ଟେମ୍ବରରେ ଆପଣ କାହିଁ ଯାଉଥିଲେ ପଇସା ଧରିକି 5,000 ଟଙ୍କା?
ସେପ୍ଟେମ୍ବରରୁ ଷ୍ଟ୍ରାଇକ୍ ହେଇଗଲା ମେଣ୍ଡ।
ହଁ 5,000 ଟଙ୍କା କାହିଁ ନେଇ ଯାଇଥିଲେ? ଯଦି ସେପ୍ଟେମ୍ବର 19ରେ ଅର୍ଡର ହେଲା, 18 ମସିହାରେ କାହିଁ ପଇସା ନେଇଗଲେ? ନା ତା ସେଟା ଭୁଲ ଲେଖିଛନ୍ତି?
ସବସ୍କ୍ରିପସନ ଏଟା ଲେଖାଯାଇଛି 28/8/2019 ଅର୍ଡର।
ଠିକ ଅଛି, 18ଟା କ୍ୱେଶ୍ଚନ ଖୋଜି ବାହାର କରିବା, ବର୍ତ୍ତମାନ ସମୟ ପଳେଇବା, ତ ପଳେଇଲାଣି ସମୟ।
28/8/2019 ମାଇ ଲର୍ଡ।
ଟିକେ ପଢନ୍ତୁ ଆଜ୍ଞା ସାର୍, ଟିକେ ପଢନ୍ତୁ, ଆପଣ ପେଜ 11ଟା ପଢନ୍ତୁ।
On further perusal of the CMA.
पेज 11 पढ़ो, 19/11. It is further stated by the petitioner.
କେବେ ସେ ଡାଉନଲୋଡ କର?
ठीक है, କଥା କଣ ଲେଖି? ସେଟା ଅଲରେଡି କରିଦେଇଥାନ୍ତି।
The local version of the 2018 till more than 1 year. During that period,
ଆପଣ କୁଶଲ ପାଠଟା ଛାଡ଼ିଦେଲେ। During that period, we had been required for many times to pay the cost ଆପଣ ଲେଖୁଛନ୍ତି। Anyway, you have to verify, ଆପଣ sure ନୁହନ୍ତି, ମୁଁ ମତେ ବି ଦେଖିବାକୁ ପଡ଼ିବ। ହେଲା।
this civil proceeding
as the events have unfolded,
unexpected due to non-appearance of the
due to non-compliance of the conditional order dated 28/8/18, that question underline करते 28/8/18 for payment of cost of ₹5,000. The CMA number 9 was disposed of on 27/11/2019, declaring the order passed on 28/8/2018 in CMA number 9/2017. Hello. In view of the order dated 28/8/18, declaring that CMA number 2017 has become infructuous, the judgment and decree dated as passed in CP number 235/2013 became final. To bring home the contention that the petitioner did not pay the amount of 5,000 due to sufficient reasons. It is stated that the petitioner, the court kar debe, local bar members observed siege work from September 2018 till more than 1 year. More than 1 year, page 11, Judge. During that period, he had been to Rourkela court for many times to pay the cost for compliance of the order of the court, but could not able to make. Stop. Quote ends into bracket sick. The size. Discussing the said contention of the petitioner, At paragraph 7 of the judgment, the trial court has held that on till 27/11, sorry, till 27/11, the petitioner remained absent. After the order was passed, dated 28/11, from the case record maintained by the court, public order sheet, it is clearly evident that the wife was attending the court regularly. Hence, the court had to reject the contention that the petitioner was unable to appear due to siege work by the advocates. Para. Regarding the other plea of the petitioner regarding health condition of some of his close family members, the petitioner has stated certain events of hospitalization and passing away, an unfortunate passing away of one of the family members.
Two minor. Is he younger brother or mother?
Of family members for them.
Is he younger brother and a mother?
Which explains his non-appearance up to 7/4/2019, starting with 25/3/2019. अरे आपणक जूनियर कौन पढ़ू ना बोधे आपणकर सी तो 18 मसीह 19 मसीह जदि ऑर्डर हैला से 18 मसीह कौन कहउचंती जे से एप्रिल मासरे के चली गला ऑब्वियसली इट इज 18 कौन लिखले but apparently the order in favor of the petitioner restoring the order restoring the petition was passed in 18/8/2018. Therefore, the said plea has also failed to convince the learned trial court. The present application is under 227, akin to exercising the power of revision bestowed upon this court. The scope of revision has been delineated by the Honorable Apex Court in Samima Faruqi, paragraph Kalia versus Lipin Behra Kalia versus Itisri. You know RPFM number 13. It's already court he jayichi. Para 15 ta setre jayichi. In view of the above discussions, this court does not find any illegality or infirmity in the order. The same has been passed upon proper appreciation of materials on record as well as the pleadings of the parties and the evidence. Accordingly, the writ application fails and is dismissed. I have the other assignment I have to write. So all these matters where you want adjournment are no difficult. You want listing, he will give you a date, but please bear, next week there is some difficulty due to social engagements. So he will adjust. जोड़ा टच छोड़नी से दरकार नहीं अपन don't chop up the tree like that person. When it is not reached, you will always take the plea. Not see it was not reached. It will never expire.
My lord, item number 31, my lord.
Matter which mentioned ହେଇଥିଲା Mr. Manas Pati for the item 14 ଲେଖନ୍ତୁ Mr. Manas Pati for the petitioner. এটা অর্ডারটা ডাকিବାକୁ ପଡିବ 14
along with
I mean mentioned at the beginning 80 এটা ডাকিବାକୁ ପଡିବ ଯୋଉଟା 11 mention ହେଇଥିଲା ତାକୁ ତ କମ୍ପ୍ଲିଟ କରିବାକୁ ପଡିବ ନା I have accepted those memos please appreciate that 17ଟା 2 weeks କରିଛନ୍ତି ହେଲା ସେଟା ଆପଣ ସୁବିଧା ଅନୁସାରେ ଦେବେ ଆଉ ଆଡଜର୍ନମେଣ୍ଟ ଗୁଡାକ ଆପଣ ନିଅନ୍ତୁ ମତେ ବାଧ୍ୟ ମତେ କୌଣସି ମଡେଲ ଦେଖିବାକୁ
Item number 31, my lord.
Kindly appreciate. ଆପଣଙ୍କର any date you are suggesting
Yes, sir. Date ମୁଁ କହୁନି because of pendency of the case before this honorable court, family court was unknown, my lord, cannot pass a final order.
sir you are listing ଆପଣ listing
Not listing ଅଛି 31 ଅଛି 31 ଅଛି ସେଥିରେ
sir time is over
yes sir ସେଥିରେ
time is over there is no further time I cannot pass orders
sir
once I stop dictating মানে of course there are matters so many matters mentioned in the 11th so those are added to my today's dictation but for other matters I cannot because then I have to pass in his matter so how can I ignore it
and just your lordship just looking the matter your lordship
list not today please appreciate
ସେଥିରେ କଣ
you
ହିସାବ
take a date sir ଗୋଟେ date କରିଦିଅ
এটা স্যার 16 ତାରିଖ ଅଛି family court ରେ sir because by virtue of direction of this honorable court family court fixed 16th
16 କେତେ କହୁଛନ୍ତି
16th ଅଛି
ମାର୍ଚ୍ଚ ନା ଫେବୃଆରୀ
ଏଇ ଫେବୃଆରୀ
ପରଦିନ ଆଜି କେତେ
ଆଜି ସାର୍ 10
12 କୁ ରଖନ୍ତୁ
ମୋର 20ରେ 425/25 ଟା ଆଡ ହେଇକି ଆସୁ ତା ଆଲମ ହେଇକି ଆସୁ
ସେଟା ମେମୋ ଦେଇଦିଅ
ଆଜ୍ଞା
ସେଟା ଅର୍ଡର ହେଇଥିଲା ଜୁଡିସିଆଲ ଅର୍ଡର ହେଇଥିଲା
ତାହେଲେ ସେ ମେମୋରେ ଲେଖିଦେବେ ନା
ମୁଁ ଦେଇଦଉଛି
ସେମାନେ ବେଳେ ବେଳେ ଅଫିସରେ ମିସ୍ କରୁଛନ୍ତି ଯୋଉ ନୂଆ ପିଲା ରିକ୍ରୁଟ ହେଲେ ସେ ବୁଝି ପାରୁନାହାନ୍ତି ସୋ ମେନି ଥିଙ୍ଗସ୍ ସେଟା ଦେଇଦିଅନ୍ତୁ
ଦେଖୁ ସାରିଦେବେ କିଛି
no prioritization
My lord, in terms of our trustee TRPCRL, total list that is
ଶୁଣନ୍ତୁ
two IF.
you have already asked you I have told your senior I cannot take up the matter after the list is over
No, my lord.
so you take a date
yes
Sorry.
date ନିଅନ୍ତୁ adjournment ନିଅନ୍ତୁ but please accommodate the manner will be first orders then after notice then hearing
Along with TRPC, sir.
ସେଟା କରିଦେବେ ତାପରେ ଆପଣଙ୍କର ଏଇ 16 ୱିକ୍ ଟା ଛାଡିଦେବେ 23 ରେ ବହୁତ ଗୁଡେ ଲିଷ୍ଟ ଅଛି ତ it has to be distributed because if you start hearing the matter seriously this time is consumed because if you submit less I will take less time because I am trying to dictate in the court itself ଆପଣ ଗୋଟେ ମ୍ୟାଟର ଚାଲିବ ଯଦି ଘଣ୍ଟେ ଆର୍ଗ୍ୟୁ କରିବେ କଣ କେମିତି ହବ ସବୁ ମ୍ୟାଟର କଣ ମାନେ ଏଲାବୋରେଟ ଲାଇକ କେଶବାନନ୍ଦ ଭାରତୀ କଣ ସେମିତି କରିବା କଥା ନୁହଁ must understand that interim petition ରେ ବି ଆପଣ ଆର୍ଗ୍ୟୁ କରିବେ ଗୋଟେ ଘଣ୍ଟା